Please rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
The Clerk of Court will please call the matter at hand.
Yes, Your Honor. GR number 229781, Senator Leila M. de Lima versus Honorable Juanita Guerrero in her capacity as presiding judge, Regional Trial Court of Muntinlupa City, Branch 204 et al. Appearing as counsel for petitioner are Attorney Alexander A. Padilla, Attorney Teddy Esteban F. Rigoroso, Attorney Florin T. Hilbay, Attorney Jose Manuel I. Jocno, and Senator Wigberto E. Tanyada. Appearing as counsel for respondents are from the Office of the Solicitor General, we have Solicitor General Jose C. Calida, Assistant Solicitor General Renan E. Ramos, Assistant Solicitor General Marisa B. de la Cruz Galandines, Assistant Solicitor General Bernard G. Hernandez, Assistant Solicitor General John Emmanuel F. Madamba, Assistant Solicitor General Rex Bernardo L. Pascual, and Assistant Solicitor General Hermes L. Ocampo. Thank you, Your Honors.
All right. Meron ka bang question? Okay. We will just defer for a few minutes the interpellation of Justice Calida. Justice Velasco just wants to ask one question from Attorney Hilbay. Meantime, all the others will please take their seats. Attorney Hilbay, please. I hope that the Clerk of Court has already informed all the counsel that we will have a long session. So prepare yourself to work until 7. Justice Velasco, please.
Madam Chief Justice, Attorney Hilbay,
yes, Your Honor.
I was furnished a copy of the affidavit of Attorney Maria Cecil Tresvalles Caballo only today. Did you read the affidavit of Attorney Caballo regarding the notarization of the petition of Senator De Lima?
Yes, Your Honor.
Did you have a hand in the preparation of said affidavit?
No, Your Honor.
Okay. So, it is the allegation of the Solicitor General that Attorney Caballo as a notary public did not have any opportunity at all to notarize the petition before us. So during the oral arguments, you stated before the court that she was actually able to, that Attorney Caballo was able to meet Senator De Lima on February
24.
2017. Is that correct?
Yes, Your Honor, it's in the affidavit.
And who told you that Attorney Caballo actually met Senator De Lima?
I read the affidavit, Your Honor.
The affidavit of Attorney Caballo was already
yes, Your Honor.
prepared last Tuesday? Is that what you're saying?
Your Honor, I read it before you last Tuesday.
Okay.
If you remember correctly, Your Honor.
Okay.
I asked you if you could allow me to read certain paragraphs, and I read certain paragraphs of the affidavit. And
Correct. Did you talk to Attorney Caballo about the contents of this affidavit? Did you
No, Your
discuss-
Honor, I have never met her. I only have her affidavit.
Do you know, can you tell us what's the meaning of a jurat? Probably you're not a notary public or never had
I'm
been.
not, Your Honor.
Okay, under the 2004 rules on notary public, a jurat refers to an act in which an individual on a single occasion appears in person before the notary public and presents an instrument or document. Letter B, is personally known to the notary public or identified by the notary public through competent evidence of identity as defined by these rules. Letter C, signs the instrument or document in the presence of the notary. And D, takes an oath or affirmation before the notary public as to such instrument or document. Okay? Can you go over the affidavit of Attorney Caballo again? And
Okay. Let me read, if I may, Your Honor.
Okay, please read the
paragraphs.
paragraphs, starting with paragraph 4. Up
Yes, Your Honor.
to
Paragraph 2.
Paragraph 11. Okay,
Yeah.
go ahead. Just to put it on record.
Okay, Your Honor. On paragraph 2, Attorney Tresvalias Caballo says, I have notarized the petition for certiorari and prohibition with application for a writ of preliminary injunction and urgent prayer for temporary restraining order and status quo ante order on February 24, 2017 of Senator Laila M. De Lima.
Excuse
On
me,
the-
Attorney Albay, can you go straight to paragraph 4?
Okay. On February 24, 2017, at or around 9 in the morning, I went to PNP CIDG Camp Crame, Quezon City to notarize the petition as discussed the previous night. Would you?
Go ahead na,
Okay,
paragraph
on paragraph 5, I met Senator De Lima when she was brought to the CIDG at Camp Crame, and I was informed that the petition was already signed and ready for notarization.
Okay, stop there. So, the petition was already signed at the time she met Senator De Lima, meaning that Senator De Lima did not sign the petition before Notary Public Tresvalias Caballo.
Well, Your Honor, they discussed the contents of the petition the night before. Senator De Lima is personally known to the notary public. No one is disclaiming the contents. No one is disavowing any statement in the petition. I mean, what are we talking about here, Your Honor?
Well, the 2004 rules on Notary Public clearly states that the person must sign the document before the Notary Public. Okay? What does the jurat of this petition state? Can you read?
All right. Here's the verification. Okay. Would you like me to read the entire verification, Your Honor?
Jurat, it's usually the same statement that you put in the jurat. That is subscribed and sworn to.
Okay.
Doesn't it say? That's correct, right?
Yes, of course.
Subscribed and sworn to before me. Meaning to say that Petitioner de Lima is required to sign the petition before the notary public. In this case, notary public Tres Valles Caballo. But her very affidavit shows that it was already signed, and she just met Senator de Lima at the CIDG at Camp Crame.
Yes.
But the conclusion that can be reached from the affidavit of Tres Valles Caballo is Senator de Lima did not sign the petition, her name, and that she did not swear before Notary Public Tres Valles Caballo. Can you read paragraph 6? Can you read paragraph 6?
Okay.
Can you read paragraph 6?
I was then provided the petition by her staff. I examined the signature of Senator de Lima and confirmed that it was signed by her. I have known the signature of the senator given our personal relationship. Nonetheless, I still requested from her staff a photocopy of her government-issued valid identification card bearing her signature. A photocopy of her passport was presented to me. I compared the signatures on the petition and the passport, and I was able to verify that the petition was in fact signed by her. Afterwards, I attached the photocopy of her passport to the petition, which I appended to my notarial report.
Okay, so paragraph 6 clearly shows that the petition was already signed by Senator de Lima before the staff of Senator de Lima gave her the petition. Okay? Now, did Attorney Caballo put the impression of her seal at the time that she allegedly met Senator de Lima? Do you know that, or you're not aware of that?
I'm not aware, Your Honor.
Okay. So from the very affidavit alone, it shows that there was a non-compliance with our 2004 rule on notary public. That's all, Madam Chief Judges.
Thank you, Attorney Hilbay. Solicitor General Calida will please approach the rostrum and make the presentation in 10 minutes.
Your Honor, please, may I respectfully request for an additional 10 minutes, Your Honor, so that I can read everything in a deliberate manner, Your Honor.
Attorney Anama, did we give an additional time last the first session? Okay, Soljan, please proceed.
Additional 10. Thank you very much, Your Honor. May it please this honorable court. A litigant must come to court with clean hands. A party who comes to court with unclean hands cannot be allowed to profit from her own wrongdoing. Senator de Lima is not exempt from this time-honored rule. At the outset, de Lima attached fabricated jurats in both the verification and certification against forum shopping and affidavit of merit of her petition. De Lima, in conspiracy with her sorority sister, Attorney Maria Tres Valles Caballo, a notary public, falsified the jurats mentioned earlier. De Lima never appeared before Attorney Caballo to swear and subscribe her affidavit as attested to by the concerned police officers who arrested her and held her in custody. Attorney Caballo herself confirmed in her belated affidavit, and I quote, "I was informed that the petition was already signed and ready for notarization. I was then provided the petition by her staff," unquote. Attorney Caballo's affidavit is an admission that she and de Lima committed falsification and violated Section 6 of the 2004 Rules on Notarial Practice, which requires the affiant on a single occasion to appear in person before the notary public. Because the jurat in the verification and certification against forum shopping was fabricated, the instant petition is considered unsigned, pursuant to Section 4, Rule 7 of the Rules of Court. An unsigned pleading produces no legal effect. The absence of a valid verification also means that the LIMA's petition suffers from a fatal infirmity. It does not comply with Section 1 of Rule 65, requiring that a petition filed under the rule must be verified. Similarly, Your Honors, inasmuch as the jurat in the affidavit of merit was falsified, it should be treated in like fashion and considered as not having been executed. It is as if the LIMA did not execute the affidavit of merit at all. For these reasons alone, Your Honors, the LIMA's petition should be dismissed. Because of their brazen actions, both the LIMA and Attorney Caballo are liable for falsification. They are also liable for indirect contempt of court and for violation of the Code of Professional Responsibility and the lawyer's oath. The LIMA is therefore not entitled to any relief from this court. She is not blameless. Her hands are not clean. Besides, there is no reason for this honorable court to give the LIMA special treatment. Her case is only one of the tens of thousands of drug-related cases now being handled, practically asking this court to waive its rules so that the court can rule on an incident still pending before Respondent Judge Juanita Guerrero. My answer, Your Honor, is none. Let me now discuss the procedural issues identified by this court. Forum shopping. The LIMA is guilty of forum shopping. She admitted that she has a pending motion to quash with the trial court. A reading of this motion and the instant petition reveals that there is an identity in the parties, rights asserted, and relief sought in the present petition and in her motion to quash. Both implead as parties the LIMA herself and the people of the Philippines. Both also seek substantially the same relief to enjoin the criminal proceedings against her. This is a clear case of forum shopping. In Senator Estrada versus Office of the Ombudsman, this honorable court ruled that Senator Estrada was guilty of forum shopping when he filed a petition for certiorari before it, despite the pendency of his motion for reconsideration on the finding of probable cause against him in the Office of the Ombudsman. By parity of reasoning, the LIMA committed forum shopping because she immediately went to this honorable court on the present petition, despite the pendency of her motion to quash before Judge Guerrero. Hierarchy of courts. The LIMA, no matter her stature, is not exempt from the principle of hierarchy of courts. Under this principle, direct recourse to this honorable court is improper because it is the court of last resort. Apropos, the court may act on petitions for certiorari, prohibition, and mandamus only when they are absolutely necessary or when serious and important reasons exist to justify such exemption to the policy. The LIMA's case does not fall within the exceptions. Her petition before this court does not involve issues imbued with public welfare and policy. Neither does it show that there are exceptional or compelling circumstances or that the broader interest of justice demands the direct action of the court. The petition also failed to establish that the order of Judge Guerrero finding probable cause to issue a warrant of arrest against the LIMA is a patent nullity. Prematurity of petition. The LIMA filed a motion to quash before Judge Guerrero on February 2017, serving a copy thereof to the prosecutors via registered mail. The motion was set for hearing on February 24, a Friday. On the date of the hearing, Judge Guerrero issued an order giving the prosecutors 10 days from receipt of the order to comment on the motion to quash. On February 27, a Monday, DeLima hastily filed the petition with this honorable court, even if Judge Guerrero had not yet resolved the motion to quash. Simply stated, DeLima's petition for certiorari and prohibition is premature. Had DeLima not been precipitate in filing the petition, she could have obtained her desired relief in the motion to quash, which is the plain, speedy, and adequate remedy provided by the rules. She ought to realize that this court is not a respecter of persons. In her undue haste, DeLima forfeited other plain, speedy, and adequate remedies which could have equally addressed her concerns, such as a motion for reconsideration of the February 23 order, motion to quash the warrant of arrest, motion to recall the warrant of arrest, motion for judicial determination of probable cause, and motion for reinvestigation, to name some. These procedural infirmities warrant the dismissal of the present petition. May I now go, Your Honors, to the substantive issues of this petition. RTC jurisdiction. Jurisdiction is defined as the power and authority of a court to hear and try and decide the case, People versus Mariano. The history of relevant penal laws unmistakably shows that the RTC has original and exclusive jurisdiction over drug offenses enumerated in RA 9165. Moreover, the epigraph of Section 90 of the law is jurisdiction. Section 90 is the first section under Article 11, which is entitled Jurisdiction over Dangerous Drugs Cases, quote unquote. This section authorizes the Honorable Court to designate regional trial courts to exclusively try and hear cases involving violations of RA 9165. Such exclusive jurisdiction of the RTC to try and hear drug cases is expressed in Administrative Matter number 5-9-03-SC, which states, and I quote, "The phrase to exclusively try and hear cases involving violations of this Act means that, as a rule, courts designated as special courts for drug cases shall try and hear drug-related cases only. That is, cases involving violations of RA 9165 to the exclusion of other courts, period. Pursuant to Section 90 of RA 9165, only courts designated by this court as special courts for drug cases can take cognizance of the violations of RA 9165. Under this circular, this honorable court designated RTC as the only drug courts to the exclusion of the Sandigan Bayan. In fact, the Sandigan Bayan has not tried any drug case since its creation. Even before the enactment of RA 9165, this honorable court issued AM number 00-801-SC, designating certain branches of the RTC as special drug courts. Later, this honorable court designated all the RTCs as drugs courts, to the exclusion again of the Sandigan Bayan. Expressio unius est exclusio alterius. The expression of one thing is the exclusion of another. Because the Sandigan Bayan was not mentioned, this honorable court never intended to designate the Sandigan Bayan as a drugs court. There is another reason militating against the argument that Sandigan Bayan has jurisdiction over the offense charged in the DeLima case. Under the catch-all provision of Section 4B of the Sandigan Bayan Charter as amended, only offenses committed in relation to office by the public officers specified in Section 4A fall within the exclusive original jurisdiction of the Sandigan Bayan. The information does not allege that DeLima committed the offense of conspiracy to commit illegal drug trading under Section 26B of RA 9165 in relation to her office. Besides, in People versus Benipayo, this honorable court held that, and I quote, "The grant to the Sandigan Bayan of jurisdiction over offenses committed in relation to public office did not divest the RTC of its exclusive and original jurisdiction to try written defamation cases, regardless of whether the offense is committed in relation to office. The broad and general phraseology of Section 4 of the Sandigan Bayan Charter, as amended, cannot be construed to have impliedly repealed or even simply modified such exclusive and original jurisdiction of the RTC. Even in RA 10660, which was enacted after Benipayo, did not impliedly repeal RA 9165. Well settled is the rule in statutory construction that implied repeals are disfavored. In order to effect a repeal by implication, the latter statute must be so irreconcilably inconsistent and repugnant with existing law that they cannot be made to reconcile and stand together. There is no irreconcilable conflict, Your Honors, between RA 9165 and the Sandigan Bayan Charter, as amended by RA 10660. They can be reconciled by way of legal hermeneutics. RA 9165 confers on the RTC's exclusive jurisdiction over drug offenses. On the other hand, the Sandigan Bayan Charter confers on the draft court jurisdiction over offenses committed in relation to public office to the exclusion of drug cases. Although the information mentions the LIMA as, quote, taking advantage of her public office, unquote, in the case of Montilla versus Hilario, such allegation was considered merely as an aggravating circumstance and not one that qualifies the crime as having been committed in relation to public office. De Lima was properly charged with conspiracy to commit illegal drug trading under Section 26B of RA 9165 in relation to Section 3JJ and Section 5 of the same law. Section 26B punishes conspiracy as a crime in itself. Section 5 was mentioned in the information to indicate the imposable penalty, which is life imprisonment to death. The Council of De Lima makes much ado over the alleged fundamental disagreement between the OSG and the DOJ as to the crime charge. This supposed conflict is more imagined than real. The recital of the facts and circumstances in the information determines the offense charged and not the technical name, caption, or preamble given by the public prosecutor in the information, in the case of Lacson versus Executive Secretary. In this case, the ultimate facts of the information charged De Lima and her co-accused with conspiracy to commit illegal drug trade. When parsed, Section 26B has the following elements. First, two or more persons come to an agreement. Second, agreement is to commit drug trading using electronic devices such as mobile or landlines, two-way radios, internet, etc., whether for money or any other consideration in violation of RA 9165. And third, offenders decide to commit the said offense. The information in the De Lima case is specific in both the technical designation and material averments, which make out a case for conspiracy to commit illegal drug trading under RA 9165, one of the unlawful acts mentioned under Article 2 of the same law. This is not a case of first impression. In People versus Fabro, this honorable court stated that conspiracy refers to mere agreement to commit the offense of selling, delivering, etc. of dangerous drugs and not the actual execution thereof. While the rule is this mere conspiracy to commit a crime without doing any overt act is not punishable, the exception is that when such is specifically punished by law. The conduct of the Lima, Ragos, and Dayan, together with the high-profile inmates, before, during, and after the commission of the offense, evinces a common design to commit illegal drug trading punishable under Section 26B by legislative and judicial fiat. This crime is cognizable exclusively by the RTC. De Lima and her co-accused are not charged with direct bribery under Article 2010 of the Revised Penal Code. At least two elements of that felony are missing. The DOJ panel of prosecutors knowingly did not investigate De Lima for violation of Article 210 of the Revised Penal Code. This is why the joint resolution of the DOJ panel dated February 14, 2017 recommended that the charge of direct bribery be endorsed to the Office of the Ombudsman for appropriate action. Probable cause. Judge Guerrero determined probable cause in accordance with Section 5, Rule 112 of the Rules on Criminal Procedure. Her action is in accord with this Honorable Court's 2017 en banc ruling in Marcos versus Cabrera Fallier, decided January 24, 2017, that upon the filing of the information, the first and foremost task of the judge is to determine the existence or non-existence of probable cause for the arrest of the accused. Judge Guerrero did just that. 6 days after the filing of the information, Judge Guerrero issued an order finding probable cause to issue a warrant of arrest against De Lima and her co-accused. She arrived at such finding after an examination of the information and evidence. Judge Guerrero was satisfied that based on the evidence admitted, there is substantial basis that a crime has been committed and that the persons to be arrested are probably guilty of their crime. Judge Guerrero is not yet tasked to review in detail the evidence submitted during the preliminary investigation. It is sufficient that she personally evaluated such evidence in determining probable cause. All that is needed for a finding of probable cause is substantial basis, which is even less than substantial evidence, as this court held in banc in Estrada versus Office of the Ombudsman. In any event, Judge Guerrero's evaluation of the evidence warranting the finding of probable cause cannot be raised before this honorable court because it is not a trier of facts. TRO. De Lima seeks the issuance of an injunctive writ, TRO, or status quo ante order to restore her liberty. In effect, she is asking this honorable court to grant her freedom without being entitled to it as required by the rules of court. This cannot be permitted. De Lima is charged with a non-bailable offense. To grant her plea for the issuance of a status quo ante order is to flout Section 7, Rule 114 of the Rules of Court, prohibiting the grant of bail to persons charged with an offense punishable by life imprisonment or death. She ought to know that she can only be granted bail if and only if the evidence of the prosecution is not strong. Nevertheless, De Lima is badgering this honorable court for a status quo ante order to circumvent the prohibition under Section 7 of Rule 114. Besides, what is sought to be prevented by the writ of preliminary injunction TRO is essentially the incarceration of De Lima, hence her prayer to set aside the order of warrant of arrest. She has, however, already been arrested prior to the filing of this instant petition. The matter is now fait accompli. Injunction does not lie to restrain consummated acts. De Lima's petition is a paradox. She is asking this honorable court to enjoin Judge Guerrero from conducting further proceedings until and unless the motion to quash is resolved with finality. In short, De Lima wants Judge Guerrero not to act and to act at the same time. In closing, the frailties and overweening ambition of the LIMA opened the portals of the National Penitentiary to narco-politics. It resulted in the proliferation and flourishing of illegal drugs trading within the walls of Bilibid and beyond. Her actions seriously impaired the health of many Filipinos who became addicted to illegal drugs. This irretrievably ruined their lives. Surely she should not get away from this. My plea, Your Honors, on behalf of the people is this. Kindly dismiss the petition and let another woman, a veteran trial judge, a bar examiner in criminal law, and a professor in criminal procedure, the Honorable Juanita Guerrero, finish her task. Unlike the LIMA and her lawyers, my office has faith in the impartiality, ability, and experience of the trial court judges like Judge Guerrero to dispense justice without fear or favor. Fiat justitia ruat caelum. Let justice be done, though the heavens fall. Thank you, Your Honor.
Thank you, Mr. Solicitor General. We'll have Justice Velasco commencing the interpellations.
Thank you, Madam Chief Justice. Mr. Solicitor General, you said that we should respect the rule on hierarchy of courts. Is that correct? We should respect the rule on the hierarchy
Yes,
of
Your Honor.
courts.
She should. Because she's not only a senator, she's also a lawyer, Your Honor.
Okay. During the oral arguments, the counsel or petitioner Dilima said there are exceptions to the rule, and that she relies on the fact, on the allegation that there are genuine issues of constitutionality. What can you say about that? Is there any constitutional issue raised in this petition?
I do not believe there is a constitutional issue here, Your Honor.
What specifically are the grounds that she raised?
Well, Your Honor, can I refer to the petition, Your Honor?
Anyway, I'll read it, Mr. Solicitor General. Number 1 issue, respondent judge gravely abused her discretion, which amounted to lack of jurisdiction, when she issued the questioned order and warrant of arrest despite dependency of petitioner's motion to quash, and despite the clear merits of said motion that impugns the jurisdiction of the court. Is there a constitutional issue here?
None at all, Your Honor.
The second ground she raised is that respondent judge gravely abused her discretion, which amounted to lack of jurisdiction, when she issued the questioned order and warrant of arrest in clear violation of constitutional and procedural rules on issuing an arrest warrant. Is there a genuine constitutional issue here?
None, Your Honor.
Okay. Again, petitioner Dilima relies on another exception to the general rule that the issues she raised in this case are of transcendental importance. What can you say about this contention of the petitioner?
I don't see any transcendental importance, Your Honor. What I see here is a violation of the rules of court.
You're saying respondent judge violated the rules of court?
No, Your Honor. Dilima, when she filed this petition before this honorable court.
It was petitioner who violated the rules of court.
Yes, Your Honor.
There is a statement here, or there is a contention on the part of the petitioner that the basic principle is that the trial court must first resolve the motion to quash based on lack of jurisdiction before she can issue a warrant of arrest. And this is captured under paragraph 28 on page 22. Is this the established principle in this jurisdiction?
No, Your Honor. In fact, I just cited a recent ruling of this honorable court in Marcos versus Cabrera Falier that the first and foremost duty of the judge is to determine the existence or non-existence of a probable cause, whether or not she can issue the warrant of arrest.
And And the reason why a warrant of arrest must be issued in non-bailable offenses is so that the trial court can have jurisdiction over the person of the accused. Is that correct?
Yes, Your Honor. And besides, this is a criminal, the case is a criminal case, Your Honor. There is public interest that the criminals cannot flee from the jurisdiction of the courts, Your Honor.
Why is it important that the court must first acquire jurisdiction over the person of the accused?
Well, it is important, Your Honor, in the sense that under the rules, she can immediately, when she issues the order of warrant of arrest, that she can be arrested so that she can be brought to the court, Your Honor.
And she will be forced to comply with the orders of the court? Is that what you're saying?
Yes, Your Honor, because she will now be in custody.
There is a ruling that says the warrant of arrest must be issued so as not to frustrate the ends of justice. What does that mean?
I agree, Your Honor, because the ends of justice is that the guilty shall not be allowed to go scot-free, Your Honor.
Is there a jurisdiction over the territory or place where the crime was committed?
That was
case?
stated, Your Honor, in the information.
And
The
then
crime was
another-
committed in Muntinlupa, Your Honor. And Judge Guerrero is an RTC judge sitting in Muntinlupa, Your Honor.
Correct. And another essential requirement before a court can acquire jurisdiction over a criminal case is jurisdiction over the subject matter of the case. Is that correct?
Yes, Your Honor.
And what is your contention on this? Does the RTC court presided by Judge Guerrero have jurisdiction over the offense or subject matter of the information?
Yes, Your Honor, under Section 90 of RA 9165, it is the RTCs which has exclusive and original jurisdiction over drug offenses, Your Honor.
So it is that your claim is that the RTC has jurisdiction over violations of the Dangerous Drugs Act.
Yes, Your Honor, that is so stated in the law itself.
That is the one captured in the four corners of the information. Is that correct?
Yes, Your Honor.
Okay. That's all, Madam Chief Justice.
Justice Leonen. I'm sorry, Justice Mark. Justice Leonen, go ahead. All right, Justice Del Castillo. No, the justices like each other very much. They keep on yielding. Justice Del Castillo, please.
Good afternoon, Counsel.
Good afternoon, sir. Your Honor.
The authority of the Ombudsman to investigate offenses involving public officials and employees is concurrent with government prosecuting agencies such as state and regional prosecutors. But in the exercise of her primary jurisdiction, she may take over a cases which are within the exclusive jurisdiction of the Sandigan Bayan. Do you agree, Counsel?
Yes, Your Honor.
And when you say that a case is within the exclusive jurisdiction of the Sandigan Bayan, what do you mean?
When it falls under the Sandigan Bayan Charter as amended, Your Honor.
That the public official has a salary grade of 27 and above, and that the offense committed was in relation to her public office.
Yes, Your Honor.
You mentioned that the offense committed here is conspiracy to commit trading of illegal drugs.
Yes, Your Honor.
And that the offense was performed with abuse of her public office. Would you equate that, the abuse of public office, with in relation to public office?
Well, technically, no, Your Honor. That is just an aggravating circumstance and not a qualifying.
What is the aggravating circumstance?
Your Honor, in the case of People versus Magallanes, the allegation of taking advantage of his position or taking advantage of the respective positions is not sufficient to bring the offenses within the definition of offenses committed in relation to public office. That is also the ruling in Montilla versus Hilario, that such an allegation was considered merely as an allegation and not of an aggravating circumstance, and not as one that qualifies the crime as having been committed in relation to public office.
What then exactly do you mean by saying that an offense has been committed in relation to public office?
It is not the same in legal effect as to offenses committed in relation to public office, because in relation to public office presupposes there is an intimacy, Your Honor, an intimacy and
you mean that the public office is a constituent element of the crime itself? That's what you're saying?
Yes.
That's when you say intimacy,
Yes,
of
Your
the
Honor.
public office and the offense committed. Is that what you're saying?
It is the, let me explain, Your Honor. In relation to the office, the principle laid down, Your Honor, in Montilla versus Hilario, that an offense may be considered as committed in relation to the office if it cannot exist without the office, or if the office is a constituent element of the crime as defined in the statute, Your Honor.
Would you give examples of these crimes? Would you say, for instance, that direct bribery?
One good example, Your Honor, would be malversation of a...
What about direct bribery? Is direct bribery a constituent element? I mean, is the position of Secretary of Justice a constituent element of the offense of direct bribery?
No, Your Honor.
And you were also about to say falsification.
Malversation, Your Honor, would be a constituent
Malversation.
element. Yes, Your Honor. Of a, for example, a treasurer, a finance officer of the government.
And would you say that...
Because when
would you say, counsel, that this is the reason why the petitioner would insist that the crime or the offense for which he is being prosecuted is direct bribery, so that if it were direct bribery, then obviously it would fall under the jurisdiction of the Sandigan Bayan. Is that what you're saying?
That is probably her strategy, Your Honor.
And on your side, you're insisting that the crime committed was conspiracy
Yes, Your
to
Honor.
commit trading in illegal drugs.
With the use of electronic devices, Your Honor. That is also part of the charge in the information.
And that is taking advantage of her public office.
It has no, Your Honor, it has no relation with her office.
The conspiracy, what you're saying, the conspiracy to commit trading in illegal drug, that's committed by taking advantage of her public office. That's what you're saying.
I think that's what the information says, but I don't have it before me, Your Honor. As I mentioned earlier, Your Honor, in my opening statements, there are at least two elements that are missing, Your Honor, if the charge is for direct bribery. The elements of direct bribery are the following. The offender is a public officer. Number two, the offender accepts an offer or promise or receives a gift or present by yourself or through another. Number three, that such offer or promise be accepted or gift or present be received by the public officer either with the view of committing some crime or in consideration of the execution of an act which does not constitute a crime but the act is unjust. And C, to refrain from doing something which is his official duty to do. The act which the offender, and number four, the act which the offender agrees to perform or which he executes is connected with the performance of his official duties, meaning in relation to the office. Now, one of the elements that is missing, Your Honor, in direct bribery in this information is this. In direct bribery, the offender accepts an offer. But in the information, Your Honor, or rather, in direct bribery, the offender not only accepts an offer, but he receives a gift or present. But here in the information, the conspirators, meaning the Lima, Ragos, and Dayan, demanded, solicited, and extorted money. They were the ones asking, Your Honor, the high-profile inmates. It was not being offered as a gift to them or being promised to receive this particular gift. So that alone excludes direct bribery from this information, Your Honor. The other element missing in the information is that there is no relation to the office. Their acts had no relation to their office, Your Honor. But here in the recitals, Your Honor, of ultimate facts, all the elements of the offense punishable by under the drug law are present. And may I name them, Your Honor. First, two or more persons come to an agreement. There were more than two persons, the Lima, Ragos, and Dayan. The agreement is to commit drug trading using electronic devices, such as mobile or landlines, two-way radios, internet, etc., whether for money or any other consideration in violation of RA 9165. This element is present here, Your Honor, in this information. When it says conspiring and confederating, etc., did then and there, rather, the offenders decided to commit the said offense. That's the third, which in the information also states, Your Honor, that did then and there commit illegal drug trading. So they decided to commit it, Your Honor. And the manner in which they committed is peculiar only to this section, Your Honor, because they're using electronic devices.
Counsel,
so this falls
yes, I think we've heard enough on the issue. The co-conspirators of the petitioner, they're inmates, Counsel. They're inmates, high-profile inmates.
Yes, Your Honor.
Would you say that they would be conspiring with a person who would not be, for instance, occupying the high position of Secretary of Justice?
Your Honor,
in other words,
there are two types of conspiracy, Your Honor.
How could they possibly, how could the Secretary of Justice how could she have committed the offense you're alluding to her if she were not Secretary of Justice?
Well, Your Honor, she's a high public official for one. The conspiracy, Your Honor, there are two types of conspiracy. One is the so-called wheel and hub conspiracy, and the other one is the chain conspiracy. In the the hub and wheel conspiracy, the center of the wheel is the LIMA, Your Honor. And the spokes are Ragos and Dayan. Now, they already, they are the conspirators, actually, the main conspirators, Your Honor. Now, in her desire to have money to finance her senatorial ambition, Your Honor, Dilima being the inducer and Ragos being one of the conspirator by indispensable cooperation, they were able to recruit these high-profile inmates.
That is only your conclusion.
Yes,
what
Your
is
Honor.
your proof that it was the petitioner who induced these high-profile inmates to conspire with her to commit trading in illegal drugs?
Well, that is the ultimate fact, Your Honor. They conspired with each other.
What's your proof of that?
At this stage, Your Honor, we, with all due respect, this is not yet the time to prove all of these allegations in the information, Your Honor. We are just, the task of Judge Guerrero was just to find a probable cause for the issuance of a warrant of arrest, Your
Thank you, Counsel.
Thank you, Your Honor.
Justice Leonen.
Good afternoon, Counsel.
Good afternoon, sir.
Can I beg your forbearance for the first part of my questions. It will be a bit hypothetical, but you will see the relation later. So my first question is, can a Metropolitan Trial Court issue a warrant of arrest for the crime of murder? Can a Metropolitan Trial Court issue a warrant of arrest for the crime of murder?
Well, Your Honor, I believe that is not within his jurisdiction.
So can a Metropolitan Trial Court issue a warrant of arrest for the crime of murder? So yes or no? No, it cannot.
No, Your Honor.
Supposing there is a Metropolitan Trial Court that does issue a warrant of arrest for murder, what is the remedy of the person against whom the warrant of arrest is issued?
Well, he should file a motion for reconsideration, or he can challenge, Your Honor, the issuance of the warrant of arrest, or he can ask for the court to inhibit himself.
But then, in the meantime, the person against whom the warrant is issued is incarcerated, correct?
Well, Your Honor, I know that you're asking hypothetical questions, but I don't believe any MTC judge will issue a warrant of arrest for
We adjust
murder.
it a little. So
Because,
this
Your
is a
Honor,
crime under either Section 5 in relation to 3JJ, which is trading, or under Section 26, correct?
are we still in the
Yes,
murder
we're going
case,
to
Your
the
Honor?
LIMA case. The crime charge is either 9165 Section 5 in relation to 3JJ trading or Section 26.
Yes, Your Honor.
Can you, which
We-
one?
Our position, and this is upon agreement of the DOJ and the OSG, is that based on the recital of facts and the ultimate facts in the information, the crime there is violation of Section 26B.
Section 26.
Yes,
okay.
Your Honor.
Now, has there ever been a conviction under Section 26?
I'm not aware of any conviction, but there was a case before under RA 6425, if I'm not mistaken, Your Honor, the People versus Fabro.
I am
Which
pointing
has-
to only Section 26, 9165.
I'm not aware, Your Honor.
Okay. Is there another public official that is now being charged under Section 26, 9165?
I really don't know, Your Honor.
Mayor, a barangay captain, a former undersecretary, except this case? None.
I'm not aware, Your
Yes.
Honor. It doesn't mean that there is none. I'm not aware.
Is it the intention of this administration to go after those involved in what you referred to in the first page of your comment as narco-politics? Is there an intention to go after all those involved in narco-politics?
Yes, Your Honor.
And is there an intention to go against them aggressively? By
Not-
aggressive, I mean using the rule of law, correct?
Using the rule of law,
Yes.
yes, Your Honor.
Yes.
That's the duty of the state.
So there will be more politicians that will be charged under Section 26, correct? Or maybe Section 5, correct?
Hopefully, yes, Your Honor.
Yes, and politicians that have enticed, participated in drug trading using the Believe It, correct?
Yes, Your Honor.
Because according to one of the affidavits, I think this is from J.V. Sebastian, as well as the affidavit of Afghanistan, and this is submitted to the court. 70% of trading in drugs go through the Believe It. Is that correct?
I think you're correct there, Your Honor.
Yes. So therefore, we have to get it right. We have to know whether it is the RTC, not the Sandigan Bayan, or vice versa, that has jurisdiction. Because if there were 1,000 cases to be filed by this administration with the wrong court, your efforts will be put at naught, correct?
Yes, Your Honor.
Yes. And if it is done through the wrong court, therefore, there will be a lot of dismay with respect to the promises of this administration. We want to help the administration in terms of being able to provide for speedy and continuous trial that is being worked on so that there will be a fair and full conviction if the merits contain that. But in case the RTC does not have jurisdiction, that would mean at the end that there will be thousands and thousands of cases that will be filed with the RTC but then nullified because it does not have jurisdiction, correct? So it is better that in this case that is now before us and we have the opportunity that we now rule on which court has jurisdiction to assist the administration's efforts on the war on drugs so that you will do it following the rule of law. Is that not correct?
Yes, Your Honor.
So you agree that we should now rule on the jurisdiction with respect to which court has jurisdiction over 26, Section 53JJ in relation to public officers. Is that not correct?
Well, Your Honor, first, this honorable court should rule whether or not the petition of the LIMA should be granted or dismissed, Your Honor.
But that is an exception with respect to the three things that you have been pointing as part of the regular function: judicial efficiency, judicial administration, and can you imagine? I know that you have a very thick list of narco politicians. I saw the president in many press conferences showing the thick list. Now, I am sure that the Department of Justice is now working on that. And they are now trying to determine where they're going to file, ombudsman first or through the DOJ. So therefore, this case might be the golden opportunity for this court to finally say that it goes through the RTC or the Sandigan Bayan. Okay. Now, Mr. Solgen, just in case we grant this petition and say that the RTC made a mistake, it cannot, like the MTC, in my analogy, it cannot issue the warrant of arrest because it did not have jurisdiction over the subject matter. It is the Sandigan Bayan. Will that mean that you cannot prosecute former Secretary and now Senator De Lima? If we grant the petition on a procedural ground that the jurisdiction is with the Sandigan Bayan, does that mean that you cannot prosecute with all the evidences that you have presented, and I think it is in these two piles, that you cannot prosecute with the Sandigan Bayan?
Well, with due respect, Your Honor, before we even go to the jurisdiction, I think the petition of the LIMA should be dismissed outright, Your Honor, for not following
Yes, that's another point, and I'll go to that
the rules
later.
of court.
I'll go to that later, but I'm just asking you for clarification. In case this court dismisses the petition on a procedural ground, or grants a petition on a procedural ground, that it must have been filed with the Sandigan Bayan, can the DOJ, with all its fantastic prosecutors, be able to still continue to prosecute the crime charged here in the information with the Sandigan Bayan?
Your Honor, it is my humble submission that the RTC has jurisdiction over this drug case
just in case that this court will say that it is not the RTC but the Sandigan Bayan. I'm just asking you in terms of the strength of the probable cause. Will it be able to pursue, and does it have the political will to pursue the crime charged with the Sandigan Bayan if this court tells you that it is the Sandigan Bayan that will have jurisdiction?
Well, may I preface my answer, Your Honor, that I hope not.
Yes,
that
of
the
course you hope
Supreme
not.
Court
You're the
But-
respondent. But
Yes,
just in
Your Honor.
case.
Well, in the remote event that will be the decision of this honorable court, Your Honor, I believe the Department of Justice can do its job, Your
Yes.
Honor.
And it is possible that a warrant can issue from the Sandigan Bayan, and that will be the basis for actually incarcerating Senator De Lima. Is that not correct?
Based on my prefatory cautionary statement, Your Honor.
Understandable.
Yes, Your Honor.
Yes. And any of the proceedings that has happened in the RTC will not affect the procedure in the Sandigan Bayan because there is no res judica, there is no double jeopardy because this is a criminal case, and among others, correct?
Actually, Your Honor, if that is the
Subject
trend,
to your precautionary statements a while ago, yes or no?
yeah, Your Honor, if that is the trend of the questions, Your Honor, even Judge Guerrero can rule on that, Your Honor, in the motion to quash.
Precisely. Okay, so therefore, if we rule on a procedural ground, the prosecution against the senator will not be put at naught. We are not undermining the case of the prosecutors at this early stage. If we rule only on the question of jurisdiction. Okay, now, my next point is, my next set of questions is this. We have a president who says what he means and means what he says. Will you agree with me on that?
Yes, Your Honor.
Yes, and precisely why there were so many that actually voted for him is because they see him as very transparent, correct?
Well, he has a, let me call it this way, Your Honor. People voted for him, number one, because they want change.
Yes.
And Mayor Duterte, who is now the president, embodies the longings and desires of most Filipinos, Your Honor.
Yes. So, would you say that the president has spoken against the senator on several occasions?
Let me qualify, Your Honor, the speeches that he makes. Sometimes, when he talks to the people, and there are times that he is joking, there are times when he's serious, there are times when he's angry.
Would you know whether he is joking, the statements were a joke or a serious matter?
It would depend on the circumstances, Your Honor.
Because in the petition, there are very grave allegations regarding the statements of the president. For instance, the petitioner is an immoral woman for having an affair with her driver. Did the president actually say this?
I'm not personally aware that he said that, Your Honor, but the petitioner admitted that she had relationships with Diane before.
Petitioner allowed the drug trade to proliferate because of her boyfriend, who was also her married driver. That came from the president. It can come from you because that is your case, but I'm just wanting to know whether it was the president.
I have no
said.
personal knowledge whether he said that or not, Your Honor.
Okay, it was the petitioner who opened the portals of narco-politics in government. You said that? but
Yes, Your Honor.
I just
yes.
want to know whether it was also the president that actually said that.
That is my statement, Your Honor.
Okay. And these statements were not made of any other person in the list, in that thick list, presented by the president as people involved in narco-politics. Is that not correct?
Come again, Your Honor.
In
I
other
didn't get
words,
it.
only the senator, only the former secretary was the subject of these statements made by the president. Actually, counsel, I have a statistical count. based upon the petition only, and these are only allegations, let me just clarify that. These are not my statements. I'm just wanting to clarify from you. I have a statistical count of the number of times that the President actually said, 37 statements about the petitioner on 24 different occasions from August to November of last year alone. Okay, but in any case, this is based on the petition only, the table that was submitted by the petitioner. Of course, these are statements of fact. Okay, now my question now is, have these statements been made also of another individual other than Senator De Lima?
Again, Your Honor, I have no personal knowledge whether another personality
Would you have personal knowledge that this administration focused on Senator De Lima as one of its flagships in terms of prosecution against narcopolitics?
With all due respect, I do not agree with how the sentence was phrased, Your Honor.
Okay, can you rephrase the statement? Is this not a priority of the administration, this case?
The priority of this administration, as far as I know, Your Honor, is to curb and curtail the proliferation of drugs in the Philippines.
Okay. This case or incidents arising from this case was heard in the House of Representatives. Is that not correct?
Yes, Your Honor.
Would you know who presented this case in the House of Representatives? Again, this is just a clarification of the statements made in the petition.
That was the initiative of the House of Representatives through its committees, Your Honor.
But we know
various committees.
what presentation means. In other words, who actually asked the questions from the witnesses during the hearing of the Committee on Justice in the House of Representatives. Would you know?
I think there were many who asked questions, Your Honor.
But who actually initially presented it?
Well, Your Honor, I did not watch the entire proceedings, but I saw in one instance where I think the Secretary of Justice was one of those who asked questions.
In fact, the Secretary of Justice was the one that presented the witnesses first before the interpellations happened, correct?
Maybe, Your Honor, because I was not
The
there.
whole nation watched, Mr. Solicitor General.
Yes,
So
Your
I'm just asking you now. The whole nation watched, and they saw what I am just asking you. So is it true that it was the Department of Justice Secretary that presented the witnesses before the committee? Of course, the chair of the committee explained why, but I'm just asking you whether it was indeed the Department of Justice Secretary that presented the witnesses.
Well, Your Honor, I trust your statement, Your Honor.
Okay.
If that is what happened, then so be it, Your Honor.
No, I'm not saying it. I'm just asking you. And you declined to answer, but I'm just saying now that the whole nation watched. And you are now refusing to confirm that it was the DOJ secretary?
No, he was one of those who asked questions. That's what I know.
Did
for a
he
fact,
inhibit
Your
from
Honor.
this case? Did the Department of Justice secretary inhibit from this case?
Well, he was, I think he did not inhibit in the sense that he was asked by the Committee on Justice to present these inmates who were under the control
I mean
and
the criminal
supervision.
case. In the preliminary investigation, did the Department of Justice secretary inhibit? In other words, had there been questions coming from the panel that it will not go to the Secretary of Justice in case there is a petition for review? Has there been an inhibition by the Department of Justice?
If we look at the resolution of the DOJ, Your Honor, the Secretary of Justice was not part of it.
Okay.
Even the information was not approved by him. It was approved by the Prosecutor General.
Yes. Is Herbert Colanco a co-accused in this case? Herbert Colanco, the drug lord, it is part of your will a while ago. If I'm not mistaken, no, it is J.V. Sebastian. Is he part of this case? Is he a respondent?
He's not named here in the information.
What about
Your Honor.
Colanco?
He's not named also here.
What about any of those that testified in the House of Representatives and submitted their affidavit? Are they respondents in this case?
Well, I have the information before me, and I don't see the names,
Yes.
except there is an allegation of the high-profile inmates, Your Honor.
Yes. So are they respondents to this case, or do they have immunity?
I think they were accepted into the Witness Protection Program, Your Honor.
Who approves the acceptance into the witness protection program?
It is the director in charge of the Witness Protection Program, Your Honor.
I'm sorry, Mr. Solgen. According to the law, who approves? Who is admitted to the witness protection program?
Well, Secretary of Justice,
The
Your Honor.
Secretary of Justice. So the Secretary of Justice who presented this case to the public in the House of Representatives, in the Committee on Justice, is also the one approving who gets immunity in this case. Is that not correct?
Well, the
And as a result of that,
the acceptance of the persons under the Witness Protection Program happens before any preliminary investigation, Your Honor.
yes, and as a result of that, the only respondents left in this case is Secretary de Lima, Dayan, Ragos, in
Yes,
this
Your
case,
Honor.
correct? And all the others who actually traded the drugs inside the bilibid or used the cell phones outside are not now part of this particular case. Is that correct?
They are now the witnesses of the state,
The
Your
witnesses of the state, but they are no longer the accused in this case, correct?
Honor. Yes, Your Honor.
Yes. Okay. In Broca, as well as Salonga versus Cruz Paño, there is there the exception, including the case of Martinez. There are exceptions to the rules of hierarchy, injunctions against criminal prosecution, and plain, speedy, adequate remedy in the course of the law, which the Supreme Court crafted. One of which is lack of jurisdiction, correct? Okay. The other is using the strong arm of the law to oppress a particular individual. In the words of Broca, persecution rather than prosecution. This is contained in the petition. Now, Mr. Solicitor General, can you respond to that allegation that
Okay.
this case is persecution, not prosecution? So I just want a clarification from you. What will your response be to that allegation?
The cases of Broca, Salonga, and Samson, Your Honor, provide for exceptions to this general rule. They do not apply to the instant petition because, number one, the offenses cited in the offenses in the cited cases are political crime, rebellion, sedition, etc., while the instant case involves a common crime under RA 9165. Number two, the cases involve situation with clear abuse in government to prosecute, strong arm of the law during martial law, which is not present in this case, Your Honor. And number three, there is no ground for the criminal prosecution to be restrained or stayed by injunction, whether it's preliminary or final, Your Honor.
Thank you, and I hope that both parties will cover this more in their memoranda because it is, I think, a crucial basis that is contained in the petition. Now, let's go to the question of probable cause. Okay. Assuming that the court has jurisdiction over the subject matter, according to you, the first task of a judge in that case that you mentioned, which by the way was a disciplinary action case, that 27 Judge Marcos versus Perla Cabrera Falier. Okay, in any case, because they have to issue a warrant of arrest, you are saying that one of the first tasks would be to look at the documents that are submitted to it by the prosecution. Is that not correct?
Yes, Your Honor.
Yes. And the documents are, well, physically, this is how thick they are, correct? This is your submission of all the affidavits as requested by the court. Is that not correct?
Yes, Your Honor.
Yes. It was submitted to the court, correct?
I think so, Your Honor.
Yes. And the court had to determine for the first time the elements of Section 26. Is that not correct? In other words, it had to read the law and look at the elements of the offense, distill it from the law, and then look at whether each and every affidavit or there are sufficient basis from the affidavits that would correspond to the elements. Is that not correct?
Yes, Your Honor.
Yes. So it would have been the first time for any judge in this country to be able to determine the elements of the offense, correct?
Yes, Your Honor.
And
But
she could rely simply on the documents and not call the witnesses to a hearing, because according to you, it would be sufficient to rely only on the documents that are presented before her. She did not have to call the witnesses. Is that not correct?
Yes, Your Honor. She did not have to call the witnesses. And besides, Your Honor, the LIMA waived her right to submit her countervailing affidavit, Your
That was
Honor.
preliminary investigation. We are talking
Yes.
about preliminary examination before the trial court.
And therefore, the explanation of the LIMA was not part of the records.
Yes, of course, because in probable cause determination, that is preliminary examination, only the complainant and the witnesses are going to be called, correct?
Yes, Your Honor.
Definitely,
but,
the LIMA will not be called for the probable cause hearing for the warrant of arrest unless she filed a motion for judicial determination. Normally, according to the Constitution even, personally examining the complainant and the witnesses, or the witnesses it may produce, only one side for the issuance of a warrant, correct? So the LIMA is not involved here. So my only question is about whether the judge correctly only relied on the documents. And according to you, yes.
Not only the documents, but even the information. And
So there is no exception in our jurisprudence with respect to that particular rule, that the judge can only rely on the documents presented before it when determining probable cause.
that is, yes, Your Honor, under Section 5, Rule 112 of the Rules of Court.
Howe versus People, 2014, Justice Brion. The determination of probable cause may not only be with the documents if it appears to be only a mindless acquiescence to the prosecution's findings, correct?
Well, I believe in this case,
People versus Ho, Lim versus Felix also, after Sullivan versus Makashar. In fact, Sullivan versus Makashar, which was the basis for this rule, clarified that yes, the judge can rule on the documents, but it must make sure that there is probable cause. Is that not correct?
that is her personal evaluation, Your Honor.
now,
And considering
Probable
the...
cause must not be only hearsay evidence, correct? It has to be personal knowledge of the witnesses, correct?
Yes, Your Honor. And
The Agkawili case, Rowan case, right? And the case of Quintero versus NBI. All of these cases say that when you determine probable cause, the judge must assure itself that the evidence is not merely hearsay, that there must be personal knowledge of the witnesses involved, correct?
in Senator Estrada versus the Ombudsman, Your Honor, what is necessary is only substantial basis, Your Honor.
Yes, I agree with that. But the substantial basis is set up by personal knowledge of witnesses presented, because hearsay evidence per se is inadmissible, correct? And
Yes, Your Honor.
according to the case of Rowan in the 1980s, clearly when it is hearsay, the oath cannot bind the person testifying. And because preliminary examination is one side, then therefore the oath becomes very important because there is no cross-examination. So it has to be personal knowledge, correct?
Personal knowledge of
Of the witnesses.
the witnesses.
Yes.
That's
correct?
the rule, Your Honor.
Yes. And the affidavits that you submitted, from the point of view of a good lawyer, would you say that all of them are on the basis of personal knowledge?
I would like to believe so, Your Honor.
So when a drug lord inside the Believe It says, sinabi sa akin ni ganito na ibibigay ito kay De Lima, that's personal knowledge?
But that was confirmed, Your Honor.
Really?
Yes, when, for example,
So
one of the drug
all
lords...
the facts in the affidavits are actually corroborated by each other, correct?
Yes, Your Honor.
Because I read every affidavit that is contained there, And it was difficult for me and my staff to actually create a timeline where there was a corroboration of substantial points. For example, do you have the affidavit of Diaz with you? Diaz.
Right now, Your Honor?
Right now.
I don't have it, Your Honor.
Just to show you, paragraph, can one of your staff actually look for the affidavit of Diaz? And, well, let us go.
May I request the clerk of court to please indicate, these are the submissions, Attorney Anama? The affidavits can be found there? Can you ask one of your assistants to please look at the affidavits that are already here beside Attorney Anama?
In any case, counsel, paragraph 28 of the affidavit of Diaz states the source of the money that he has supposed to have given through intermediaries to the LIMA. And it is very clear there that he says it did not come from drugs, except that there is a subsequent question, paragraph 29, which actually shows that it was the investigator that suggested by a leading question that drugs were involved. In any case, I'm just saying that there is such an affidavit which actually says that. And based on the affidavit itself, would you say that any judge really wanting to be impartial should have called the witness in order to ask more searching questions of that witness?
Pardon me and forgive me for asking this, Your Honor, but are we now assessing the
We are not assessing-
substantive evidence, Your Honor?
We are not assessing the substance of the evidence unless you're not familiar with it. We are not assessing it. We are just looking at the exceptions for the doctrine that the judge only relies on the document, and that the judge, in many cases of certiorari, have been told by this court that he or she should have called the witnesses when there were indicators that relying on the documents were not sufficient. That's a doctrine. That is Lim versus Felix. That is Howe versus People. That is People versus Ho. I am just asking you whether it is, in your opinion, right for Guerrero, or whether there was grave abuse of discretion in the determination of probable cause that she did not call the witnesses. Considering that, it was not clear where the sources of funds were coming from. Case in point, the affidavit of Diaz. In other words, I'm not saying that Diaz was telling the truth. I'm just saying that based on the affidavit, there is doubt. But in any case, there was also the affidavit of this deep penetration agent or agent of the CIDG, whose code name is Afghanistan, who later on was presented as Mr. Arile. Are you familiar with him?
I'm not familiar with that, Your Honor.
In any case, just to show you that he wrote a letter to President Duterte through General Ronald Bato de la Rosa on August 4, 2016. And that is annexed in the documents that you submitted to us in his affidavit. And in that letter, there does not seem to be an allegation that De Lima was involved in drug trading. This is the informant of the CIDG inside. But in a later affidavit, that is September 2016, he did mention that Senator De Lima was involved in terms of getting money from the drug lords. So we have two documents from the same person. One, August 2016, and the other, September 2016. Now, my question is not the credibility of this witness. My question is, should the judge not have called the witnesses and asked more searching questions before issuing the warrant of arrest?
My position here, and with due respect, Your Honor, is that Judge Guerrero enjoys the presumption of regularity in the performance of her duty, Your Honor. And I believe this is not the time to look at the evidentiary matters, Your Honor, because this honorable court is not a trier of facts, Your Honor.
In Rowan, in the case of Martinez Agkawili, Quintero versus NBI, where it was raised to this court that there was grave abuse of discretion on the part of the trial court in determining probable cause, this court went into the nature of the evidence that was presented, not to determine the credibility of the evidence, but only to determine whether there was sufficient basis for the judge to have called for the witnesses. Okay, in any case, just to share with you, that is a reading of this, okay? Many of the affidavits point to Diane as the conduit. Some of the affidavits point to Jonel Sanchez. Other affidavits point to Ragos. As a matter of fact, your own will only mentions two. Actually, there is a fourth one. There is Jad, J-A-D. And I'm still trying to figure out what actually that means, J-A-D in all caps. There were 4 conduits to Senator De Lima. Your will itself only shows 2, Ragos and Dayan. Now, the question here is, wasn't there sufficient contradictions in the affidavits such that the trial court, if she had actually perused the documents, would have been enticed or mandated to actually call the witnesses to determine probable cause, even without De Lima present, because that is only determination of probable cause.
My response to that, Your Honor, is the case of Enrile versus Salazar. It must be borne in mind that in a preliminary examination for the issuance of a warrant of arrest, the court is not tasked to review in detail the evidence submitted during the preliminary investigation. It is sufficient that the judge personally evaluates the report and supporting evidence submitted by the prosecution in determining probable cause. And also in the Webb versus De Leon case, before issuing warrants of arrest, judges merely determine personally the probability, not the certainty of the guilt of the accused. In doing so, judges do not conduct a de novo hearing to determine the existence of probable cause. They just personally review the initial determination of the prosecutor finding a probable cause to see if it is supported by substantial evidence or basis, Your Honor.
I agree with you. So you are saying that the judge can rely on the prosecutor, correct? Correct, Mr. Soljan?
Yeah.
The judge can rely on the prosecutor. Is that not correct?
On the findings of the
But you
prosecutor.
will also agree with me that this court in Howe versus People, to which I signed on, also said that the reliance on the prosecutor must not be mindless. As a matter of fact, personal determination can mean that the prosecutor's findings can be overturned by the judge when it finds that there were sufficient contradictions in the affidavits. Is that not correct?
I think when Judge Guerrero examined the evidence and the report and the information, Your Honor, she was not mindless. She's a veteran judge, Your Honor. In fact, right now, I think she's handling more than 40 drug cases, Your Honor.
Neither here nor there, counsel. I'm just saying we are trying to figure out what the doctrine is. And whether it's Judge Guerrero or Mr. Juan de la Cruz or Judge Juan de la Cruz, it's not the concern of this justice. My concern is whether there was sufficient objective contradictions in the documents that were presented to entice a judge under its duty to actually personally call the witness and ask it of searching questions and answers so that there be no grave abuse of discretion. But let's move on to another point. That's just something that I hope that you can also cover in your memoranda clearly.
Yes, Your Honor. We will, Your Honor.
With those that were allegedly part of the conspiracy with Senator De Lima, again, my concern is that they were granted immunity. Is that not correct?
As witnesses of the state, yes, Your Honor.
But in order to be granted immunity, the law is very clear. They must not have been convicted of a crime involving moral turpitude. Is that not correct?
I believe, Your Honor, it is the prosecution's judgment that counts here, Your Honor.
So Nonilo Arile, this is Afghanistan, committed murder and kidnapping. Jojo Baligad, homicide. Herbert Colanco, robbery, apart from 14 other pending cases involving robbery in van. I can go on. Okay. So you have here a case where all these that are not qualified for the witness protection program but in conspiracy with Senator De Lima are not named in the information? Would you say that there is a singling out of the accused? Because that is what the petition accuses.
I don't think so, Your Honor. First, they were granted also legislative immunity, Your Honor.
Yes, but we are not Congress. We are courts of law. So
Yes, and
we have no concern about the legislative grant of immunity. They're a completely separate branch of government. I'm more concerned about we have a law. The law is supposed to be implemented by the Secretary of the Department of Justice. It actually says in the Witness Protection Program law that anybody involved in moral turpitude cannot be allowed into the Witness Protection Program, and more importantly, they cannot be discharged as a witness. Correct?
well, Your Honor, as I said, this is the prosecutorial privilege, Your Honor, if there are no other witnesses. If there are no other witnesses.
Isn't this an indicator that there is a singling out of one person by the commission of an illegal act, which is to segregate others who should have been also part of the accused?
This is not a singling out Senator De Lima, Your Honor. She chose to deal with these inmates inside the Bilibid, Your Honor. So she must reap the consequences.
Let me help you a little.
She chose to have conspiracy with the players in the drug
Let me help
business.
you a little. Sections 33, subparagraph 4 of Republic Act 9165. You know what it contains?
Come again, Your Honor.
Section 33, 9165,
Section 33.
paragraph 4. The anti-drug law. Section 33, paragraph 4. There is an exception to the Witness Protection Program, and I'm just helping you because I want to be able to cover everything that is in the law. But apparently, maybe you just missed it. So Section 33, paragraph 4, can you please read to the record?
Okay, Section 33, paragraph 4 of RA 9165. The informant or witness has not been previously convicted of a crime involving moral turpitude except when there is no other direct evidence available for the state other than the information and testimony of the said informant or witness.
Okay, can you cover that in your memoranda?
Yes, Your
This
Honor.
exception. But just to be complete, there is a chapeau. There is the opening paragraph of Section 33. Can you go to the opening paragraph?
Section 33.
Yes.
Notwithstanding the provisions.
Yes. There is there a colatilia. Only any person who has violated Section 7, 11, 12, 14, 15, and 19 of Article 2 of this Act, only if they violated that can they be part of the exception, correct? So is Section 5 there or Section 26? In other words, what we are saying, the law says that if they violated the Dangerous Drugs Act, they can still be admitted to the Witness Protection Program if they are direct evidence. But only if they violate Section 7, 11, 12, 14, 15, 19. Mr. Solicitor General, I do not see Section 5, nor do I see Section 26. And if all these drug lords were actually in conspiracy with Senator De Lima, if there was actually a conspiracy, their crime would have been Section 26, correct?
Section 26B, Your Honor.
Yes.
In relation to Section 5.
And would you now agree with me that they could not have...
There is a relation, Your Honor, in relation to Section 5.
Yes, but Section 5 is not also included.
No, but it's in relation to Section 5, and Section 5 is mentioned in Section 33, Your Honor.
Yes. No, it's not mentioned. Section 5 is what they will testify to, but the actual commission of those people that will be admitted to the witness protection should be 7, 11, 12, 14, 15, and 19. Anyway, so Mr. Solgen, I will not take the time of this
May I add, Your Honor, I forgot to read. As well as any violation of offenses committed, if committed by a drug syndicate.
What are you citing, counsel?
Section 33, Your Honor.
Yes, where are you citing that? From where? In any case, Mr. Solgen, the thesis is this, and probably you can cover it in your memoranda so that we won't take much time.
Yes, Your Honor.
The allegation of the petitioners is that the law enforcers and the prosecution, the DOJ, not the Solgen, has singled out one person. And by singling out one person, it is a badge that it is using the long arm of the law to oppress. Persecution rather than prosecution. I know you have an answer, and I would very much appreciate it if that is fully covered also in your memoranda, unless
Yes.
you want to state something.
Yes, Your Honor, and we will argue that the LIMA was not singled out, Your Honor.
Yes, and probably you can explain more of that in your memoranda. Okay.
Yes, Your Honor.
So conspiracy to trade, correct? That was that is the offense, Section 26. Conspiracy to trade. And trading is defined in Section 3JJ of Republic Act 9165. Is that not correct?
Yes, Your Honor.
Yes. And Section 3JJ, can you please read it? With respect to what it means to trade.
Okay. Section 3JJ, trading. Transactions involving the illegal trafficking of
Okay, so the
dangerous
first
drugs.
word is transactions.
Yes, Your
So
Honor.
in terms of a crime, there must be proof of said transactions, correct?
Yes, Your Honor.
So in order that it is fair to an accused, that transaction must be the who, what, where, and when. It must be indicated when it happened, where it happened, who were involved in it, and what was the subject of the transaction. Would you agree, counsel?
Well, the transactions were what was described in the information.
Because if the
Your Honor.
transaction goes this way, that sometime in 2014, there was this drug trading conducted by cell phone, that would be unfair to the accused because they will have to defend for all the days of 2014. Is that not correct?
Well, insofar as the transaction, Your Honor, the only transaction that is important to us in this petition is the recital of facts in the information. It describes the transaction, Your Honor.
Yes. The transaction, it describes the transaction clearly, or does it only state the actual giving of the 5 million twice to the LIMA, but not the transaction involving the illegal drug?
Well, Your Honor, this is the offense is for conspiracy, Your Honor.
Yes, so
Conspiracy.
to trade, and therefore the trading must actually be clear in the affidavits as well as perhaps in the information, because it is difficult for an accused to defend against an amorphous transaction.
Well, it's
The date
very,
of the transaction, the people involved in the transaction, what was transacted, are essential elements of the offense.
and they are all included in the information, Your Honor.
Okay, again, cover that in your memoranda as to why your reflection or your interpretation is that it is covered in the offense.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Justice De Castro.
Your position is that there is no bribery committed, but there's no bribery charge.
Yes, Your Honor. That's the reason why the DOJ panel of prosecutors in their resolution advised the Ombudsman to handle that phase, Your Honor, the direct bribery.
Now, I'll ask you a hypothetical question. Assuming that bribery was committed as a means to commit this crime of sale, trading, etc., of dangerous drugs, or bribery was committed in the course of the commission of this offense, can you still file a charge for violation of the dangerous drugs law instead of bribery?
In that hypothetical situation, yes, Your Honor, I would still go for the Section 26B, Your
So
Honor.
it will be your choice. You will file the more serious crime. I ask that question because the crime of plunder comes to mind. Plunder is committed by committing certain predicate acts like series of malversation. So the commission of an offense punishable by the revised penal code may be a means to commit another crime penalized by a special law.
Yes, Your Honor.
So even if bribery is committed, you can still file a case for violation of Section 5 of the Dangerous Drugs Law.
Yes, because it is a drug offense also, Your
So
Honor.
now we go back to the fundamental question of who has jurisdiction over this case, which involves the violation of the Dangerous Drugs Law. There is the petitioner argues that this case should fall under the jurisdiction of the Sandigan Bayan. But the allegations of the information accuses the petitioner in this case of violation of the Dangerous Drugs Law.
Yes, Your Honor.
Now, what this matter is addressed to both the petitioner and the respondent. If this case is brought to the Sandigan Bayan, what will happen to the provisions of the Dangerous Drugs Law? Will this apply to the Sandigan Bayan, or will the Sandigan Bayan follow the charter of the Ombudsman and the charter of the Sandigan Bayan and completely disregard certain provisions of the Dangerous Drugs Law? So that is a question that we must come to which we should evaluate. If it is the Sandigan Bayan that will exercise jurisdiction over this case, which provisions of the Dangerous Drugs Law will apply to the Sandigan Bayan? There are many references here to the DOJ, the prosecutors of the DOJ, which shall have which should be given the exclusive authority to handle cases under the Dangerous Drugs Law. There are also other provisions referring to the DOJ. How will the Sandigan Bayan deal with these provisions which refer to the DOJ? Now, there is also another provision, just to emphasize the point that I am driving at. There is a provision here, Section 92, delay and bungling in the prosecution of drugs cases. Any government officer or employee tasked with the prosecution of drug-related cases under this Act, who through patent laxity, inexcusable neglect, unreasonable delay, or deliberately causes the unsuccessful prosecution and or dismissal of the drug cases shall suffer the penalty of imprisonment ranging from 12 years and 1 day to 20 years without prejudice to his or her prosecution under the pertinent provisions of the revised penal code. Now, the prosecutors appearing before the Sandigan Bayan are not tasked by this law with the prosecution of drug-related cases. So the question now is, will they be covered by Section 92? This is just one example. I just want you, both parties,
Yes, sir.
to clarify that question which is on my mind. How will the Sandigan apply the Dangerous Drugs Law?
May I answer now,
The
Your Honor?
Sandigan Bayan disregard some of the provisions, follow some of it, and what will give the Sandigan Bayan the legal basis to do that? That is all that I want the parties to clarify when they prepare their memorandum.
Yes, Your Honor, but with all due respect, Your Honor, there's really no difficulty in answering the question, Your Honor, because under Section 90 of RA 9165, incidentally, the epigraph here is after Section 90, the word next to it is jurisdiction, Your Honor. And even Article 11 on top of Section 90 deals with, and I quote, jurisdiction over dangerous drugs cases. In Section 90, the Department of Justice was tasked to handle exclusively prosecutions involving violations of this act. In fact, there are certain periods in which they should finish their investigation, and then I'm sorry. So I believe earlier in my opening statement, I made a distinction, Your Honor. This Sandigan Bayan is essentially a graft court. And the RTC in this under RA 9165 is the drugs court. So there is a clear delineation of legislative intent as to which court should handle what case. In fact, we were able to get a certification from the Sandigan Bayan that there are no pending drug cases ever in Sandigan Bayan, Your Honor. All the drug cases are in the RTCs. And all the drug offenses are being prosecuted by DOJ, not the Ombudsman, Your Honor, in RTC courts.
Want the petitioner and the respondent to look deeply into this issue, because you have opposing positions with respect to that provision of Section 90. So the other side would say that the petitioners would take the position that it is the Sandigan Bayan which has jurisdiction in this regard of that provision that you are citing.
Yes,
so
Your Honor.
I'd like both of you to show to the court how, if it is clear that if it is the regional trial court, there will be no much problem, because the references in the law is to the Department of Justice, the
Yes, Your Honor.
prosecutor of the Department of Justice. So
Yes,
there
Your
will
Honor.
be not much problem with respect to referring to the DOJ, referring to the regional trial court as the one having jurisdiction under this law. But when it is, when the proposition is that it is the Sandigan Bayan which has jurisdiction over drugs-related cases, now the question will arise, how will the Sandigan Bayan apply the provisions of the dangerous drugs law when it exercises jurisdiction over drugs cases? When the reference here are all to the DOJ, the prosecutors of the
Yes.
DOJ, and there are many other provisions pertaining to the Department of Justice, the comprehensive policies, program, the training of DOJ prosecutors, and other provisions which have reference to the DOJ. So I'd like to find out how the Sandigan Bayan will apply the provisions of the dangerous drugs law if it is the one that will exercise jurisdiction over these drugs cases.
Well, the immediate problem of the Sandigan Bayan, Your Honor, is that they were created as graft courts, and that is their expertise. On the other hand, the RTCs, they were selected as the special drugs court by this honorable court, Your Honor. So they have the experience, the training, how to prosecute drug offenses. And there are provisions here in the RA 9165 which pertains only to RTCs, Your Honor. If the Supreme Court wanted Sandigan Bayan to handle drug offenses, it should have stated so in their administrative matters, Your Honor. But as far as we know, there is no drug offense that has been or is being tried by the Sandigan Bayan, Your Honor, up to now.
That will be all. Justice Carpio.
Counsel, can we go to the verification and certification against forum shopping signed by the petitioner? On page 2, above the printed word, Laila M. De Lima, there is a signature. Are you questioning the authenticity of the signature, counsel?
Well, I'm not familiar with her signature, Your Honor. Therefore, I cannot say categorically that that is her signature, Your Honor.
But you are not questioning it.
My question is, this was not signed before the notary public,
Yeah,
Your Honor.
we'll go to that. So below the jurat, there are the words, printed words, Attorney Maria Cecile Tresvales Cabato, and there's a signature. You are not questioning that also? The authenticity of the signature?
Well, I'm not familiar with her signature, but she admitted in her affidavit that she was the one who notarized this, Your Honor.
But you are not questioning also that she is a notary public?
Well, for now, Your Honor, I will accept at face what
she is
she
a notary public.
admitted herself as a notary public, Your Honor.
Okay, but you are definitely questioning the timing of the signature of Laila De Lima. You said that this was signed by petitioner before it was shown to the notary public. Is that what you're saying?
That is what Attorney Caballo stated in her affidavit, Your Honor.
And the consequence of that, what is the consequence of that? You're saying that it renders the petition void?
It is as if it is unsigned, Your Honor.
It is as if it is unsigned?
Yeah, yes, Your Honor.
Okay. It is as if it is unsigned. It says here, subscribed and sworn to before me. What is the meaning of that? Subscribed and sworn to before me.
The affiant should be present and subscribe and swear before the notary public, Your Honor.
The affiant swears that he caused the preparation and filing of the petition, that she had read the petition and all the other statements here, correct?
And that he appeared before the notary public, Your Honor.
And the last part says, I have signed this instrument on 24th day of February 2017 in Quezon City. So that's part of her statement under oath to the notary public, correct? She said, I have signed it. That is my signature.
But in this case, because of the fact that the affiant did not personally appear before the notary public, it is as if this verification is unsigned, Your Honor.
Okay, if the affiant signed it beforehand, when she appeared before the notary public, it was already signed by her. And she says, that is my signature. I have signed this instrument on this date. And she swears to that. You still say that that is defective?
Yes, Your Honor, under the circumstances in which we explained.
You want her to sign again in the presence, to sign twice, in other words?
Well, she should have done the correct manner, Your Honor. On February 24, the notary public should have administered the oath to the affiant. That is the rules, Your Honor, under the notarial law, Your Honor.
Let us say she signed it before appearing. How do you correct that when you're saying that when she appeared before the notary public, she should sign it a second time to cure that defect? That's what you're saying. Despite the fact that she already affirmed, that is my signature.
Your Honor, under Section 5 of Rule 8, Your Honor, failure to comply with the foregoing requirements shall not be curable by mere amendment, Your Honor.
Yes.
So,
what is the issue that you're raising, that she did not sign it? Because the rules say signed in the presence of the notary public.
yes, Your Honor.
Okay. This affiant signed it before appearing before the notary public, but said that is my signature.
Actually, Your Honor.
You think it's still insufficient?
Actually,
It is as if it was not signed. That's what your point.
Yeah, that is the what the rules say, Your Honor.
Okay. So that's the only point. Let's go to jurisdiction. Is it your position that in all cases involving drugs, when it's a prosecution for violation of the dangerous drugs law, jurisdiction will always vest in the regional trial court, regardless of the salary grade or the whether the act was performed in relation to office by the respondent. Is that your position?
Yes, Your Honor.
Okay, thank you, Counsel. That's all.
Thank you.
Soljan Kalida.
Just few questions lang.
Okay,
Yeah, yeah.
Justice Peralta.
Just few questions, Chief. Now, did you read the order of Judge Guerrero when she ordered the issuance of a warrant of arrest? You recall that there was an order of Judge Guerrero that before the issuance of a warrant of arrest, she came
Yeah.
out with an order.
Yes, Your Honor.
I think that's dated February 23. Yeah, I think it's dated. Will you please go over the records?
The order was dated February 23, 2017, Your Honor.
When did Judge Guerrero receive the records? When did Judge Guerrero receive the records from the Office of the Clerk of Court?
I think 6 days before she signed this, Your Honor.
Yeah, based from my records, the judge received the records on February 20, 2016. Is that accurate?
The information was filed on February 17, Your Honor.
And then raffled to the sala of Judge Guerrero on February 20, 2017. So anyway, based from the petition, the records were received by the RTC February 20, 2017. And the arrest warrant was issued February 23, 2017. So that means that Judge Guerrero went over the information and the records submitted by the prosecutor within two days.
3 days.
Yeah, within 2 days, because she received the order February 23, 2017. So my question, Soldier, is this, no? Did she comply? Did Judge Guerrero comply with the requirements under Rule 112, Section 5, Paragraph C, that she had 10 days to go over the information to determine the existence of probable cause?
Yes, Your Honor. She did it within that period.
Did she likewise comply with the decisions of the court in the case of Felix, cases of Felix, Aliado versus Jokno, the case of Senator Lacson, that she must determine the existence of probable cause based on the resolution, the affidavits, the evidence attached to the information?
Yes, Your Honor.
She complied.
Yes,
right?
Your Honor, she did.
Now, what do you understand by probable cause before the issuance of a warrant of arrest? Is it the same as probable cause for the filing of the information?
Well, probable cause is the judicial determination of probable cause, Your Honor, is one made by the judge to ascertain whether a warrant of arrest should be issued against the accused. The judge must satisfy himself that based on the evidence submitted, there is necessity for placing the accused under the custody in order not to frustrate the ends of justice, Your Honor.
Okay. Now, let's go to are the convicted accused who testified, who executed their affidavits, included in this particular case? Are they also being charged in this particular information? They are not. I'm referring to those convicted accused.
The inmates.
They are not.
No, Your Honor.
They are not. But according to you, they were afforded the benefits of the Witness Protection Program.
Yes, Your Honor.
Now, is there a difference between a witness under the Witness Protection Program and accused who is discharged to be utilized, a state witness? Is there a difference between the two?
I believe they are similar, Your Honor.
They are similar. So,
Yes.
But according to you, extending benefit to a witness under the Witness Protection Program is a prosecutor's call.
Yes, Your Honor.
In other words, it will depend on the prosecution if that witness will be given protection under Witness Protection Program.
Yes, Your Honor.
But in a discharge of an accused, it is a court's call.
Yes,
It is
Your
a court's call because the accused is charged together with the witness to be discharged is likewise charged in the same information.
Honor. Correct, Your Honor.
That's why it is a court's call, because if you move for the discharge of an accused, the court will hear the motion to discharge him, and then the prosecution will establish the presence of the requirements in order to be discharged.
Yes, Your Honor.
So that's a court's call.
Yes,
If
Your
you
Honor.
want to be discharged now. I ask you that question because if somebody then questions an accused, a witness, to be extended the benefit of a witness protection program, what would be the remedy?
Come again, Your
For
Honor.
example, a witness, no, there is a disqualification, and that the accused would like to question the prosecution while he was discharged as a witness. What would be the remedy of that accused?
Well, he should file a motion for reconsideration with the Department of Justice, Your Honor.
Can he go to court and then say that this witness should have not been afforded the benefits under the Witness Protection Program? Can he do that?
Because, as you said, Your Honor, that is the prosecutorial privilege or call, Your Honor.
Because as I ask you that question, because in one of the famous cases that the court has decided, where an accused was discharged and he was convicted of a crime of robbery, larceny, the court allowed him to be discharged, an accused, to be discharged as a state witness, and the basis of one of the bases of the conviction of the accused was the testimony of that accused who was discharged, and he was already convicted of a crime of robbery.
Yes, Your Honor.
And apparently there was moral turpitude. Yeah, you read the case of Larrañaga.
Thank you, Your Honor.
I'm referring to the case of Larrañaga. That's not all. It's not all that because he was convicted of a crime involving moral turpitude, he cannot be discharged as a witness.
Thank you, Your Honor.
Now, in the case of Broca, was there already a ruling on forum shopping? Was there already forum shopping in that case of Broca? Was there already forum shopping in the case of Broca? You're not aware of that?
I read that decision a long time ago, Your Honor.
Yeah, I
so-
think, to my recollection, there was no yet rule on forum shopping during that time.
Yes, Your Honor.
Yeah, I asked you that question because in the case of Broca, the issue was first raised in the RTC. And the judge then was, I think, joined the court later on as court administrator, not Justice Pespi. So in other words, there was only one case that was filed. It was filed before the RTC, and then the party was not satisfied, Broca, they came to the court. But in this particular case, the issue was raised in the RTC.
Yes,
while
sir.
waiting for the resolution of the RTC, Senator De Lima came here.
Yes, Your Honor.
So there's a big difference between the case of Broca and the case of De Lima, because now her case really falls under the rule on forum shopping.
Yes, Your Honor.
Now, let's go to. Yeah, I came from the Sandigan Bayan for 7.5 years. I've been handling a lot of cases. There is only one case that I handled where an accused as a public official is charged in relation to office. There was only one case. I think it was a case of murder involving a congressman when there was a shooting incident in a cockpit. That congressman already died. So my question is this. it's very hard to come out with a case involving a public official committing a crime in relation to office. I'll give you an example. If assuming, this is hypothetical, let's take the case of a director, no? I think director is a salary grade of 27. Yeah. Can he be liable? Can he be, if he is caught in the act of selling drugs and he is a director, where will you file the case?
RTC, Your Honor. DOJ, RTC.
So, but he is a government official.
Under the RA 9165, Your Honor, this law focuses on the act itself and not on the personality, Your Honor, or the salary grades of the public official.
So when you say crimes committed by public official while in the performance of their functions, there will be no problem, right?
Yes,
under
Your Honor.
under 4A, there's no problem about jurisdiction because the law is very clear. When the public official commits a crime in the performance of his duty as such. In other words, when the requirement of the crime is being a public official, there's no problem, like for malversation. It can only be committed by public official because those who are liable are those who are in custody of money and
Yes.
property entrusted by the government. Likewise, in a direct bribery, a public official perform or fails to perform in consideration of something. So that's always public official. But when you say involved in drugs, public official is not an essential element.
Yes, Your Honor.
The public, when you say crime, when you say the dangerous drugs law, these are crimes that can be committed by private individuals, not necessarily, not public official. That's why I
Yes,
asked
Your
you
Honor.
the question, because I cannot conceive of a situation where a public official will be liable for violation of dangerous drug law in relation to office.
Correct, Your Honor.
For example, there was a mayor from Quezon. I was just an RTC judge and we were aware of that because that was also a question that was asked of us when we were RTC judges pertaining to jurisdiction. He used the ambulance. I think you know that mayor. He used the ambulance, he used the personnel, transported several kilos of shabu. And in the checkpoint, the mayor using the ambulance was caught transporting the shabu. Jurisdiction lies with the RTC.
Yes, sir.
Because really it's very hard to conceive of a situation where one could be charged with violation of danger in relation to office. It will always be taking advantage of public position, which according to you and Justice Bersamin, it is not a qualifying circumstance. It is merely an aggravating circumstance that will only require the imposition of a heavier penalty.
Yes, Your Honor.
Yeah, am I correct?
Correct, Your Honor.
I hope so. Now, I think that's all, Chief.
Thank you, Your Honor.
Thank you. Solgen Kalida, you have
Chief.
taken the bold position of saying we had already ruled in People versus Fabro the existence of the elements of the conspiracy to commit illegal trade in illegal drugs. Is that correct?
That was the case that
Yeah. You have
under
said,
the old dangerous
Yes.
drugs law, Your Honor.
Yes. So because of the old law on conspiracy, you say that it is also applicable in RA 9165. Is that correct?
Well, in that case, Your Honor, what is important is mere conspiracy
All right.
is punished, Your Honor.
Okay. Have you read the case in the original, Solgen?
Due to lack of time, Your Honor, I relied on the...
All right. I will refer you then. Does any of your assistants have the original of People versus Fabro? And I'm looking at the portion where the court was talking about what was being appealed. Can you look at that? Have you identified the paragraph that
No, Your
talks
Honor.
about what the appellant was assailing in her conviction? Okay, let me just guide you because I don't know what version of the decision you have. In this appeal, appellant assails her conviction on the ground that her guilt has not been proven beyond reasonable doubt. She contends that the following circumstances create a doubt as to her culpability of the crime charged. First was with respect to the weight of the marijuana, that it weighed only 99.5 grams and not 1 kilo. Second, the marked money allegedly used in the buy-bust operation was not recovered and presented during trial. And third, based on the testimony of the NBI, the real possessor of the confiscated properties was her co-accused, Irene Martin. Have you already identified that portion?
No, Your Honor.
Okay.
I'm listening to you, Your Honor.
Thank you. So, after the court, under the ponensya of Justice Kapunan, went through each of the assailed evidentiary matters and how the court below disposed of the same, it therefore said that the conviction of Fabro was being affirmed. Is that correct? Do you have ASG Rex Pascual looking at it right now? It was affirmed. All right?
When you
And
say
then-
so, Your Honor, I believe you, Your
Yes,
Honor.
okay. And then near the end, ASG Pascual, you can chime in if you think that my reading of this decision is off. After the affirmance, the court said, a final note. The information denotes the crime as violation of Section 21B.
Yes.
Section 21B is the counterpart of 26 right now, which is conspiracy.
Yes, Your Honor.
And then the court went on to say, give those phrases about conspiracy. In other words, it was not even a point in issue. It was obiter. It was never controverted nor raised as an issue what are the elements for Section 21B. Because the courts below, and which was affirmed by this court, affirmed the conviction for the illegal trading or sale of marijuana. Okay? So I think that this time it would be ripe for us to really find out what are the elements of Section 26B.
Yes, Your Honor.
Okay, so this is a good opportunity for the court to finally settle this because this was never a controverted matter. So, Soljan, you represented the office, represented the VACC in the filing of the complaint before the DOJ. Is this correct?
I was there on the last day of the hearing, Your Honor, because I was a member of the VACC before, Your Honor.
So it was not really that the OSG was representing the VACC? That was not the...
I personally went there alone, Your Honor. I was there.
So the OSG never formally entered its appearance?
No, Your Honor.
Okay, so this will... I just wanted to clarify in what capacity you were
Yes, Your Honor.
attending the hearing. So, because the petitioner, I think, adverted to the fact that, in fact, the OSG was representing VACC. Is that correct?
It was me, Your Honor, in my capacity as Solicitor General and Tribune of the People, Your Honor.
So, what is the policy of the OSG in representing private parties before criminal preliminary investigations?
Well, that was my judgment call, Your Honor, considering the fact that first, I was a member of VACC, and also I believe it was my duty, Your Honor,
to continue, please.
Yes, it was my duty to be there, Your Honor.
Can you please expound on the duties of the Solicitor General's office in your memorandum and so with petitioner? Because I think I am interested in the questions that were raised by Justice Leonen in the initial part of his interpellation of whether in fact this is a common criminal investigation and prosecution or it has already reached a persecution component.
We will deal with that in our memorandum.
Okay, thank you. So because you represented VACC, you are therefore familiar with all the documents, affidavits, evidence
No, Your Honor,
submitted?
I did not get any document.
So you never saw the affidavits?
No, Your Honor.
When were you
That was
first?
the last, excuse me, Your Honor. That
Yes,
was
please.
the last hearing, actually, when I went there.
So it was the last hearing, you did not have the chance to go over the affidavits
no more,
yourself?
Your Honor. No.
So when did you first look at the affidavits of the witnesses here?
When this matter was referred to us by the Department of Justice, Your Honor.
So when this matter was first given to you, you looked first at the information?
Actually, Your Honor, I did not have the luxury of time to look into the documents at that time when the DOJ.
In preparation for this hearing, did you get a chance to look at the information?
The information, yes, Your Honor.
Resolution of the DOJ?
Yes, Your Honor.
The affidavits of the witnesses cited in the resolution?
To be candid about it, no, Your Honor, I did not go through all of
Okay,
them.
it's all right. Then I will just assist you with my questions. Do I have any PowerPoint slide for this or no? Yes? Okay, with respect to the allegations of the DOJ, first of the information. Of course, during the interpellation, we had already pointed to certain phrases in the information that is very germane to the question of whether it is the Sandigan Bayan or the RTC that has jurisdiction over these offenses and what kind of jurisdiction they exercise. They are granted. Okay. Can we look at the first paragraph which says, within the period, then there's this period, Laila de Lima, being then the secretary of the DOJ and accused, Rafael Marcos Ragos, being then the OIC of the Bureau of Corrections. All right, and this is the first the characterization of their titles is given. Then you say by taking advantage of their public office. So it is a question of whether conspiracy is the means or the aggravation of the commission of the crime, or is it a separate offense in itself. Conspiring and confederating, this is the conspiracy. And then may I point out to you the phrase, all of them having moral ascendancy or influence. And then the phrase, with the use of their power, position, and authority. Are these phrases, I think 4 already, not then already indicate to any judge that this is possibly very much an offense that is being alleged as having been committed in relation to the accused's office?
No, Your Honor. They are
Why
just
not?
aggravating circumstances, Your Honor.
All right, you're saying the aggravating. In other words, it is an abuse of authority. So you're saying they could have committed the offense whether they were public officers or not.
Yes, Your Honor.
Okay, you're saying this. And may I point out to you the panel and prosecution's joint resolution. Do we have that? I can't see that very well, please. Can I just ask the staff to just follow what I'm saying because I cannot look at it? All right. All right. I will just read the affidavits, then I will relate it to the information. The affidavit of Wu Tian Tuan Yuan, also known as Peter Ko. And allow me to read it because anyway you have your staff. They can go over the affidavits. I'm looking at page 4. And he says, hindi ko na ikinagulat na hindi nakasali ang kubol ni JB sa paggalugad. Hindi rin siya dinala sa NBI. Alam ko na dahil malakas siya kay dating Sec de Lima. Alam ko rin na ang paggalugad sa aming mga kubol at pagdala sa amin sa NBI ay paraan niya na pagpaparating ng mensahe sa amin nang hindi sumunod sa gusto niya na idaan ang lahat ng operasyon ng negosyo ng droga sa kanya ay kaya niyang ipalipat at pagtanggal ang espesyal ng pribilehiyong tinatamasa sa loob ng bilibid. Can you just, do you have the copies of the affidavits with you? Your team? All right. Am I reading it correctly? In other words, he says that the search of the kubol and the bringing of Mr. Ko, together with others, to the NBI is for the purpose of bringing the message to them that they must cooperate in the plan of negotiating or trading in drugs so that their privileges will not be discontinued. Is that correct? Did I read it correctly? Page 4?
You're reading paragraph 4, Your Honor?
No, page 4.
Page
You can
4.
look at the paragraphs. In any way, to save time, you can just confirm whether I'm reading it correctly or not. All right? You have a lot of team assistants here anyway. Let's now.
I have no reason to doubt you, Your Honor.
All right. We go to the affidavit of Jojo Baligad Irondal, page 1. Noong unang linggo ng Enero 2013, pinuntahan ako ni Commander Poy sa aking kubol. Sinabi niya sa akin na nagbigay na ng tara sa pangkat naming si OIC Rafael Ragos na 100,000 kada linggo. Ang halagang ito ay kapalit ng pagluluwag dito sa loob ng NBP. Okay? So the exchange that they wanted was the loosening of their privilege. Dahil sa pagluwag na ito, hindi na kinukumpiska ang mga kontrabando katulad ng drogang shabu at marijuana, mga cellphone, laptop computer, table, wifi receiver at signal booster. Dahil din sa pagluwag na ito, hindi na rin sinisita ang mga dapat mga pinagbabawal na gawain katulad ng pagbebenta at paggamit ng droga, pagsusugal, pag-iinom ng alak at paggamit ng babae. Page 3. Ayon sa mga narinig ko, pinalipat daw kami ni Secretary de Lima kasi may ibinigay sa kanya si JB Sebastian na lista ng mga pangalan namin. Gusto daw kasi ni JB na masolo ang sistema ng droga sa loob ng bilibid at sa aming pag-alis o paglipat, magagawa niya ito na wala di umanong kakumpetensya sa kalakal na ito. Okay? Now, with respect, another Soljan? Yes? I'm sorry, you cannot confirm it right now, no? You don't have the affidavits or do you have them? All right.
From what I heard, Your Honor, that is really an evidence to show the conspiracy
All
in
right.
illegal drug trading, Your Honor.
Yeah, I haven't gone to the questions yet. Third affidavit. Habang ini-escortan ang mga opisyal ng Bucor noong unang linggo, pinagbantaan ako ni Martinez. Ang sabi niya, amo na ngayon po, wala na ang direktor mo pero ako consultant pa rin ni SOJ. Saan mo ba gustong ipatapon? Dito niya po ako hininga ng 10,000. Upang hindi naman po ako mapatapon at malayo sa aking pamilya, sinikap ko pong makalikom ng halagang ito at ibinigay kay Martinez. Okay? That's Popoy, so Poy Lacson Trestiza. All right. The fourth affidavit. Isang beses tinawagan niya ako, meaning Ronnie Dayan. At sinabi na kung kailangan ko ng proteksyon sa aking negosyo ay tulungan namin si Secretary sa kanyang pangangampanya bilang senador. Page 5. Bilang kalakaran sa loob ng preso, hindi ka maaaring tumanggi na maging bahagi ng pagbebenta ng illegal na droga dahil matatanggalan ka ng mga benepisyo na ibinibigay tulad sa aming mga pinuno ng mga samahan sa loob ng NBP. At ang malala ay ang posibilidad na pagbantaan ng aming buhay kung hindi makikisama. That's Engelberto Acenas Durano. Okay. Just be patient. I'm
Yes,
going to just excerpt very brief paragraphs from the affidavits of your witnesses, of
It's
the
all-
witnesses
it's all
of the
right,
DOJ.
Your Honor. It's all
Thank
right.
you. 5, Joel Capones Iduro. Ipinaliwanag ni JB Sebastian sa amin na ang mga tumutulong sa paglikob ng pondo kay Secretary de Lima ay sagot niya at mapoproteksyonan at walang anumang magiging problema o panganib samantalang ang babangga ay may paglalagyan. Gayunpaman, wala naman talaga kaming may pagpipilian dahil kaya ni JB magpapatay at magpalipat sa malalayong piitan. Halos kasabay nito, page 2, kami ay pinayagan na ng mga bagong pribilehyo sa maximum security. Ako ay nagkaroon ng aircon at ref sa aking kubol. Pinayagan din ako na gumamit ng motorsiklo sa loob ng maximum security compound. Naging mas maluwag din ang pamunuan ng NBP sa kanilang pagpapatupad ng mga patakaran sa amin. Okay. 6th affidavit, Jaime Pacho. Kinausap ni JB Sebastian ako, page 1. At sabi niyang tulungan ko siya para hindi na ako maperwisyo at doon direkta niyang sinabi na bigyan siya bilang tulong sa paghanda sa pagtakbo sa pagsenador sa darating na eleksyon ni DOJ Secretary de Lima. At wag ako mangamba kasi sa kanya na raw ang administrasyon. Okay. Noel Goliosco, sa page 1. Sa katunayan, alam ng lahat dito sa Bilibid na ang salita ni JB ay parang batas. Ang sino mang hindi sasang-ayon ay maaring mamatay o taniman ng droga o itapon sa malalayong kolonya na tunay na kinakatakutan naming mga bilanggo dito sa Bilibid. Affidavit number 8, Herbert Culanco. Noong buwan ng November 2014, page 1, kinausap muli ako ni Jonel Sanchez upang i-centralize ang operasyon at inatasan din niya ako na kuhanan ko ang mga big-time drug lords ng droga ng may timbang na hindi bababa sa 30 hanggang 50 kilos. At pagkatapos ko makuha ang droga ay huwag na itong bayaran at sabihin na lang sa kanya ang pangalan ng mga drug lords na aking nakuhanan upang ang mga ito ay ipatapon nila sa ibang lugar. Hindi ako pumayag na estapahin ang mga drug lords dahil naisip ko, paano na kung wala na si Sec de Lima o ang direktor ng Bilibid? Hindi ko rin naisip na ako ay patatapon dahil nagbigay naman ako ng payola kay Sec de Lima ng 3 million at sa direktor ng 1.2 million kada buwan. 9th affidavit, Rodolfo Magleo E. Tamayo. Noong mga kapanahunan ng pangangasiwa ni DOJ Secretary de Lima, ang maximum security compound ng New Bilibid ay kinikilala bilang Little Las Vegas dahil sa talamak na paglipanan ng droga, sugal, concert ng mga kilalang singers at celebrities at prostitusyon. Halos 80% ng mga inmates ay mayroong mga cellphones at gadgets. Page 1. Page 4, binigyan ako ni JB Sebastian ng 10 milyon, binigyan ni JB Sebastian ng 10 milyon si De Lima para sa paglipat ng Bilibid ng 19 na kanyang kakompetensya at nagbibigay siya ng karagdagang 1 milyon kada buwan. Ang solo drug trading ni JB Sebastian sa loob ng Bilibid ay naging matagumpay sa loob ng 8 buwan at nagtapos ito noong nagbitaw si De Lima bilang DOJ Secretary. 10th affidavit, Rafael Ragos. During my tenure as OIC of the Bureau of Corrections, I received special requests from inmates such as long weekends to allow their visitors to stay with them for a couple of days, entry of construction materials, and conduct of celebrations inside the NBP. Inmate Herbert Colango made several requests to conduct a celebration inside the NBP. In making some of his requests, he told me that alam na ni Secretary yan, referring to Secretary de Lima. I would casually mention such celebration requests, including the request of inmate Colanco to Secretary de Lima whenever I have the opportunity to tell her, to which she would normally respond with a nod. 11th affidavit. Humingi sa akin si George ng 1 million pesos. Ang halagang ito ay sinabi ni George na para kay Justice Secretary de Lima para papasukin ang mga appliances at para payagan ang paggamit ng mga ito sa loob ng bilibid. Bago magkaroon ng actual delivery, ako ay hihiningan na paulit-ulit ng karagdagang 500,000 at ito ay sinabi sa akin na para din kay Secretary de Lima. Number 12, affidavit, German Agoho Iluna. Natatandaan ko noong Enero 2014, pinulong ni JB ang aking pangkat at kami ay inutusan na magbenta ng droga. Wala raw kami dapat ikatakot. Kami raw ay malayang makakagalaw at kami ay proproteksyonan at bibigyan ng mga pribilehyo. Ngunit kailangan naming makalikom ng 20 million para sa aming pangkat sa loob ng 3 buwan para sa suporta sa pagtakbo ni Secretary Laila de Lima. Ang hindi pagsang-ayon ay may kaukulang parusa. 13. JB Sebastian. Dahil sa lagayan ng korupsyon sa opisina ng Bucor sa panahon na ito, wala ng disiplina at hustisya ang kapwa ko bilanggo. Dagdag pa nito ay ang pakikialam ni Secretary de Lima, katulad ng pag-transfer ng Brigada 9A at paraan ng pagdidisiplina namin sa mga kakosa at ang pagbartulina sa amin ng mga commander tuwing kami ay magrereklamo upang ayusin ang pagkain naming mga inmates. Kapag hindi sip-sip kay Secretary de Lima ang direktor, tulad ng nangyari kay Pangilinan, ay tanggal ka agad. Pero kapag sip-sip, kahit anong palpak, andyan pa rin. Page 6. Gusto ko pong linawin at pasinungalingan ng mga balita o paratang na ako di umano ay untouchable at malakas kay Secretary de Lima. Ang totoo po ay sikulaan ko ang isang tunay na malakas sa Bucor at kay DOJ Secretary. Bilang patotoo nito, nagagawa niyang magpasok ng lahat ng kontrabando, babae, alak, matataas na kalibreng baril, mamahaling gamit at magpasimuno ng iba't ibang sugal sa loob ng bilibid kung saan ang pustahan nila ay milyon-milyong piso araw-araw. Kasama na dito ang paggawa ng halos lingguhang concert ni Kulangko, kung saan siya nakakapagpapasok ng truck-truck na beer at mga tao galing sa labas upang manood ng kanyang concert. Nakausap din ang aking abogado si Superintendent Schwarzkopf, ngunit sinabi ni Super sa aking abogado na tanging si Secretary de Lima lamang ang pwedeng makapigil sa aking paglibat sa Building 14. And the last, this is the last affidavit. Renante Diaz. Pagdating sa pagpasok ng mga band at performers, may request kami ginagawa sa Commander of the Guards, tapos sa Office of the Superintendent, tapos i-routing at maghihintay lang kami ng tawag ng Secretary ng Office of the Superintendent. Pero mas mabilis sa amin kasi dumidiretso kami sa Office of the Superintendent. May weekly kami binibigay, pero ang pinakasigurado ay every month sa Office of the Director, Superintendent, OIC at Commander of Guards, pati ang mga prison guards na nakabantay sa bawat gate. Pag nagpapasok kami ng babae, sinasabay namin sila sa mga bisita para hindi halata. Para sa mga gadgets, beer, alak at iba pa, sinisingit namin ang mga ito sa truck ng sound system. At kunwari, i-check ng guards para hindi halata, pero alam nila yon. Mga 4 hanggang 5 trucks ang pumapasok kasama ang generator na 350 kVA. Parang kayang pailawin ang buong maximum. Kasi, pag sobrang maramihan ang guest, kunwari, ini-endorse kami ng Office of the Director sa DOJ para masabi lang na ginagawa din nila ang trabaho nila. Okay, Soljen? Okay. You have heard, basically, the kinds of exchanges that were taking place. All of those witnesses testified to a person that in exchange for their cooperation, they were given privileges or punishments were withheld from them. Did you get the drift of those affidavits?
Well, based on the entirety of the statements, Your Honor, it's now clear that there's really a conspiracy to commit illegal drug trading, Your Honor.
Okay. The question is not really about conspiracy, Mr. Solicitor General, but would you know the legal framework for all the rules inside the national bilibid prisons? Would you know? Would you know who has the authority to order transfers, to give privileges, to disallow gadgets?
Under the rules, Your Honor, it is the Bureau Director, Your Honor.
All right. positions. This is Section 9 of the Bucor Act. Would you have the Bucor Act?
I
with
don't
you?
have it with me right now, Your Honor. I don't
You
have it.
All right. The Bucor Act of 2013, RA 10575. And I refer to Section 8. All right? Supervision of the Bureau of Corrections. The Department of Justice, having the Bureau of Corrections as a line bureau and a constituent unit, shall maintain a relationship of admin supervision, except that the DOJ shall have authority over the power to revise, reverse, modify, or modify the decisions of the Bucor, even in the exercise of its regulatory functions. Okay? Now, I refer you to one statement in the resolution which stood out very strongly, because this is quite telling. Do you have the resolution before you? The portion referring to Jesusa Susan B. Francisco. In page 27 of the 52-page resolution. And if Judge Guerrero was poring over the information and the resolution very closely, there were immediate questions that she should have asked the national prosecution officers involved. Okay? Jesusa Susan Francisco denies the testimonies of Colango and Diaz that she received on behalf of Baraan the sum of 150,000 to 500,000. All right. She claims, contrary to this, to have been threatened by Sandra Cam to testify against Baraan. She did not know Baraan personally, and she is not his staff. She works for 11 years at the DOJ Technical Services, the OIC, of reviewing documents endorsed by the Bucor. The transfer of prisoners is being approved by the director of Bucor. However, for the transfer of inmates from one colony to another, the director approves it upon the recommendation of the concerned superintendent. If the transfer is part of the rehabilitation process of bringing an inmate closer to his family, the director approves it upon the recommendation of the classification board. She claims that on June 3, 2011, the LIMA issued Department Circular Number 025 directing that all transfers of inmates to penal colonies and penal farms should bear the approval of the Secretary of Justice. Okay. In other words, Ms. Francisco was already talking about a legal framework which is necessary and which needs the authority of the designated officials before either the privilege of the inmates could be suspended or privileges could be granted, or they could be transferred from one cell to the other, or they could be transferred from one penal institution to another, including the transfer to the NBI. All right. If Judge Guerrero was reading the information, it was very clear, a resolution rather, it was very clear that she should have been alerted to the fact that the exchange being received by the prisoners was for the purpose of either suspending or granting them privileges, whether in the terms of gadgets, who can visit them, what kind of celebrations are allowed, or the transfers of their location. In all of the testimonies, there was not anything actually that Secretary de Lima could have authorized were she not the Secretary of Justice. From those who can go inside the from all of those, including the appointment of persons inside the Bucor, how the discipline and guarding of all the inmates should be done, all who can visit, how many, how long, which cell, which compound, what gadgets, what activities, all of this were within a legal framework under the Bucor Act and other related laws that could not have been allowed had they not invoked their official authority. Are you now saying, Solgen, that this is immaterial to the Sandigan Bayan's acquisition of original jurisdiction and exclusive at that, considering the other laws, the specific provisions of the Sandigan Bayan that have already been cited by some of the justices here?
I would say, Your Honor, that it is irrelevant to the offense of drug offense punished by Section 26B because, first of all, here, the office of the Secretary of Justice is not a constituent element of the crime charge, Your Honor. It is not. And
Well,
as I argued earlier, Your Honor, there are two elements missing in the direct bribery, which I need not repeat anymore. And,
I'm not talking about direct bribery anymore, no? I'm looking at the meaning of in relation to the office that is found under the Sandigan Bayan law.
yes, it has no relation to the office, Your Honor.
But none of these favors or penalties could ever have been related or connected to the personality of Secretary de Lima if she were not the Secretary of Justice. If she were an ordinary person, she could not have, if assuming that the charges, that the facts are correct, she could not have conveyed to anyone, I will transfer you to Iwahig, I will transfer you to Davao, I will transfer you here or there. She could not have at all alleged that. One necessary status she should have was to be the Secretary of Justice. If she were not the Secretary of Justice, she could not even have made these threats at all.
May I answer now, Your Honor?
Yes.
The allegation is that of taking advantage of her position or taking advantage as Secretary of Justice. This is just an aggravating circumstance, Your Honor. It does not qualify the offense. In fact, Your Honor,
So
I
this
was a
does
former... excuse me, Your Honor.
Okay, let me just follow up that question. In other words, she abused her office. In other words, she just took advantage of her office.
Yes, Your Honor. But the crime was not a what's this?
In the discharge of her functions, where she is the full where she can actually undertake all those orders that the witnesses feared she would take if they would not agree to conspire with her. All right? Isn't this more an abuse of the power related to really the kinds of cases that the Sandigan Bayan hears? In other words, in order to understand this, the Sandigan Bayan has to hear the limits of her power. And in other words, whether in fact she engages in corrupt practices in order to achieve an unlawful, by abusing in fact her power.
My take on that, Your Honor, is that the LIMA took advantage of her position in relation to her ambition to be a senator, Your Honor. And that's why there was conspiracy. Normally, Your Honor, I was a former Undersecretary of Justice. The Secretary of Justice does not micromanage what is happening in the Bureau of Corrections because that is the responsibility of the Director, Your Honor. And perhaps this is her device, this Department Order number 025, to form a conspiracy inside the Bilibid. First, he had co-conspirators like the OIC of the Bureau of Corrections, Ragos. and also her admitted lover, Your Honor. So then, pursuant to this conspiracy, they sent a chilling message to the inmates that if they will not be part of this drug trading, they will be persecuted. And therefore, the high-profile inmates mentioned in the information realized that they were better off joining the conspiracy. So the money that the LIMA received was her share in the conspiracy to commit illegal drugs, Your Honor.
But you had already listened to the questions of Justice Bernabe. She's not here with us now. And of course, Justice Carpio and the other justices, with respect to how we are to understand the Sandigan Bayan Law. And earlier this afternoon, you listened to the question of Justice Leonen, saying that the floodgates of confusion will even be opened if we do not resolve the question of who has jurisdiction in this particular case. If we do not guide, in fact, taking advantage of this particular case. I had just clarified to you that People versus Fabros cannot be a sufficient guide. Neither can People versus Benipayo be a sufficient guide. Because if you look at the language of Natura, Justice Natura was saying, both sides are wrong. They should not have spent so much time trying to define what is a crime committed or an offense committed in relation to the office. Rather, let's just look at the libel law. And then it went on to talk about the jurisdiction of the Sandigan Bayan in relation to the Sandigan Bayan law, the lower courts versus the Sandigan Bayan and versus the municipal trial courts. But it did not at all provide us a guide on what can be a crime committed in relation to one's office, because Justice Natura obviously did not said that's not material to our discussion. So what Justice De Castro was saying is that considering you have so many offenses in the Dangerous Drugs Act, we want to be able to guide everyone that to find out whether in fact all of those offenses, when it involves Section 27 salary grade officers or higher, and when there is an allegation in the information that it has been committed in relation to their office, who has jurisdiction? We also need to determine here what does it mean under the Sandigan Bayan law for a crime to be committed, what is a dangerous drugs offense that is being committed in relation to the office, as to qualify who will have jurisdiction. That is actually the dilemma that we have. Because obviously if you go and look at the witnesses here, all of them are saying that we were afraid that she would issue an order. Ragos, would issue an order transferring us from one thing to the other, denying us the benefits that we actually want. So we agree that we will cooperate so she can use her powers to achieve what are personal interest objectives also of those witnesses. So that's the key dilemma that we have. So if crimes committed within the NBP, which is the illegal selling of drugs, are being encouraged because of the use of official power which is authorized under the Bucor Act, is that not in fact something that properly belongs to the Sandigan Bayan? Because this is in relation to the exercise of clear powers that are granted Ragos as well as the LIMA. They are clearly granted these powers under the applicable law. So that is what we have to confront here. In other words, you can really, if your theory is correct, the illegal sale took place, and if she indeed received money in exchange or arising from the illegal sale, so it was a fully consummated act, then the only way that that act could have been committed and that the only way that she could have participated was through her particular position. Is that not difficult for us now that we are here? And that's why we need to confront this question.
Well, Your Honor, it's not a constituent element of the crime that she must be Secretary of Justice. Because in fact, as she had no business micromanaging the Bureau of Corrections. There are certain responsibilities and duties and authorities of the Bureau of Correction officials. That's why we have a director, we have a superintendent. There is an so that they can manage the Bureau, Your Honor.
Well, that particular...
It is rather strange that she was the one actually managing the Bureau of
All right, the
Corrections.
preference for a management style can be a policy question, whether it's good business, government, public administration policy or not. But what I'm saying is that the court is now confronted with a situation where the affidavits of all the witnesses that is going to be used for the prosecution of Laila de Lima are going to be one in saying that we participated because we wanted her to exercise her power in this way. And we would not have at all listened at all to those presentations by Sebastian et al. If she was not the Secretary of Justice. So that's the dilemma that's facing the court now. In other words, it can be similar to the dilemma of any other high-level official who will use their power to authorize the commission of illegal acts within the institutions that are under their jurisdiction. So this is what we have to confront, Mr. Solicitor General. And the importance of for the court to find a solution in this situation, to find a way to resolve this, is a very important matter for us. Because if you may allow me, and I will allow you, we will have to recall rather, no? I'm sure that you will say that you did not personally know about these statements of President Duterte, but allow me to just bring into the record what has been reported. On July 5, 2016, President Duterte announced the names of 5 police generals allegedly engaged in the drug trade. I think that's common knowledge. On August 7, 2016, he named more than 150 officials from the judiciary, police, and local government also allegedly involved in the drug trade. In fact, I sent a letter in response to that public announcement. And we have already disposed of the allegations against 3 of those, but 1 is still pending with us. On 25 August 2016, he released a drug matrix showing 7 public personalities involved in the drug trade inside the National Bilibid Prison. On December 7, he announced that he had furnished this court, the Senate, the House of Representatives, and the AFP a thick folder allegedly containing validated list of thousands of barangay captains, police officials, mayors, governors, judges, and prosecutors involved in the drug trade. Okay, I will not ask you anymore if you are aware of those, because from the questioning by Justice Leoneni are unwilling to confirm. But this is what we have listened to him, President, announce. Okay, he will take that as a given.
Do you want my answer to that, Your Honor?
Yes, please.
I find those out-of-court statements not relevant now, Your Honor, because
okay.
Because, Your Honor, the issue here actually is there is a pending motion to quash before Judge Guerrero.
Yes, that's
And
correct.
one of the grounds for that motion was I think the jurisdiction, among other affirmative
Yes.
reliefs. So my plea to this honorable court is let Judge Guerrero finish her task.
Okay. Yes, I want that question also to be answered. In fact, the question is, should we just allow Judge Guerrero, because she seems to be a very competent judge. But allow me to proceed. Okay. Now, I just want to put it on record that contrary to what was announced in the media, that the President on December 7 said that he furnished the court a copy of the list, the thick folder, listing more judges involved. We have never received such a list, for the record. So there's nothing more to act on the part of the court with respect to the President's list, but we are acting on our own on complaints related to possible cuddling by judges of drug lords. So we are doing that on our own. Solgen.
In fact, Your Honor, I sent a letter which I think you received concerning
Yes.
certain judge.
Yes,
who
we,
was
we have acted on that already. It is
granting bail. Yes, Your
yes,
Honor.
we are already acting that has already been docketed as
Thank
an
you, Your Honor.
administrative matter. Okay. Now, if the figure that had been said by the President runs into the thousands of public officials, some of whom can really well be salary grade 27 and above. And if, as I informed you and put on the record, the Bureau of Corrections Act is the one that gives the legal framework for who can have supervision or jurisdiction over the activities of drug convicts inside the NBP. In fact, are you now trying to tell us that, assuming that the President is correct, that there are thousands and thousands of government officials involved, that the court is not going to decide on the question of jurisdiction now, while we have the opportunity to do so?
Well, Your Honor, this case arose from the acts of the LIMA in directly going to this court, despite dependency of the motion to quash before Judge Guerrero. That is forum shopping at the very least, Your Honor. So let's first, my humble submission is, Your Honor, let's decide the petition on its face, Your Honor, and not dig into substantive or evidentiary data, Your Honor, because this is not yet the time to do so. There will be a time for that, Your Honor, during the trial of this case before the RTC.
Precisely, the timeliness is already being put forth before us. Justice Leonen already told you what will happen to those thousands of officials. You are basically saying that the DOJ or the Ombudsman will decide which will assume jurisdiction over the investigation, and they will on their own decide whether to file it before the RTC and the Ombudsman. Is that basically the effect of what you're saying when you're saying that we should dismiss this petition?
Yes, Your Honor. First of all, there's a defective jurat. The formal requisites of Section 1, Rule 65 of the Rules of Court was not complied with. This is just a scrap of paper that deserves to be put in the trash can, Your Honor.
All right.
As far as we are concerned.
Yes.
With due apologies to my former colleague,
All right.
my predecessor, Your Honor.
Thank you, Mr. Solicitor, that you're still a gentleman, and it's a scrap of paper, meaning it doesn't become the basis of a decision. That is your intent, actually. But we have a problem here. Not only are we faced with the possibility of the accused not knowing which charge they will finally be able to face, they don't also know which particular court will hear them. And of course, there will be therefore a constitutional question of equal protection of the laws. That all of those that the President, that the DOJ will charge, will claim to be violated when the DOJ decides to file one case before the RTC and another before the Ombudsman, referring to the Ombudsman for filing before the Sandigan Bayan, even if the constituent acts are exactly the same, or even if their situations are exactly the same. That's the problem that we have. For example, the public officials who have allowed the illegal importation knowingly of precursor chemicals. They may face the possibility of not knowing which particular court will hear them. So we want to find out if there is an equal protection of the laws issue here. And remember that when we are looking at criminal laws, we need to construe even procedural remedial laws favorably on the side of the accused. So we have to come to a uniform resolution here, because People versus Fabro is not enough, People versus Benipayo is not enough, and not for the sake of Senator De Lima, but also for the sake of all of those. Because you can very well be correct when you are charging her or her lawyers with shortcutting so many processes. But we have at many times said that this issue is so important, particularly at this time in our history, that we might jump in and already make a decision on the merits and resolve the problem, for example, of possible administrative penalties arising from a defective URAT that you are claiming, or bring on a more cautionary approach to that. So this is the situation that is before us, because if the President succeeds, if the PDEA succeeds, if the PNP succeeds in really successfully investigating and filing a case against these officials, all of them must know which court has jurisdiction. Remember that the Sandigan Bayan's decision is appealed immediately to this court. On the other hand, any RTC decision will have to go to 2 more appellate levels. That is already a major consideration. We have 3 justices for every division of the Sandigan Bayan. When they vote and there's a dissent, you can even have a division of 5. On the other hand, in the RTC, there is only 1 who will judge. This already makes a very marked difference for the treatment, so that we should not allow an arbitrary policy to be adopted either by the DOJ or the Ombudsman. So that's the situation that we have, Soljan, and I hope you can really help us resolve this.
Yes, Your Honor. In fact, right now, may I humbly offer a simple
please.
solution, Your Honor.
Yes, please.
If it's drug offense, it's RTC. If it's graft and corruption, it's the Sandigan Bayan. In fact, the Sandigan Bayan has already transferred some of its jurisdiction to the RTCs. The legislative intent here is to declog the dockets of Sandigan Bayan, not to add more cases if this court will decide that this should be the drug offenses involving certain salary grade ranks of public officers will now be under the Sandigan Bayan, which as a court has not yet handled any single drug offense.
Okay, that is as of today.
Yes, Your Honor.
We can very well say that with respect to conspiracy committed by public officials to commit any of the acts alleged there
has to be a law, Your Honor.
Well, the Sandigan Bayan law actually refers to other offenses that are committed in relation to the office
But
of
as I
these
said,
people.
Your Honor, as I said, we can use legal hermeneutics to reconcile these 2 laws, Your Honor.
Yes, please help us in that regard.
Yes, Your Honor.
You see, our drugs courts are also congested. So if the Sandigan Bayan has congestion problems, our drugs courts are also congested. So it works either way. And with respect to unloading of the Sandigan Bayan's caseload as a policy objective, I don't think that's the objective that we want to look at. Rather, we want to find out why the Sandigan Bayan was created as a special anti-graft and corruption court. And if corrupt practices were committed in relation to a special offense that has been identified by the law, such as illegal trade in drugs, we have to find out which is primordial. The corruption, graft, or abuse of power aspect of the jurisdiction that is granted to the Sandigan Bayan, or the trading in drugs. Because here, you are defending the fact that there is in the information not a single allegation that in fact sales were successful or that there were in fact identified drugs. The information only says that money was given to the LIMA. That's the problem that we have right now.
That means it was a successful venture, Your Honor. Otherwise, where will they get the money if there was no illegal drug trading?
Successful venture in the sale of illegal drugs. You are
Yes.
saying that.
No,
so
the conspiracy, Your Honor, in the conspiracy.
So the judge must presume that the 5 million that were twice given to the LIMA, the judge will have to presume that it came from the sale of illegal drugs? Are you saying that?
That was mentioned in the ultimate facts, in the recital of facts, Your Honor. That's why they did their illegal drug trading through the use of electronic devices. It's like the stock exchange, Your Honor. You want to buy or sell stocks, you call this broker and he will deal. This time it's only drug trading because that's their expertise, Your Honor.
Actually, I had tried to prepare a matrix trying to understand all the offenses in the Dangerous Drugs Act. And I tried to find out, in fact, whether it is possible, as Justice De Castro wanted us to clarify, whether the Sandigan Bayan can already identify which offenses fall within their jurisdiction and which offenses fall outside of their jurisdiction and properly within the RTC. Can both parties, the Solgen and the petitioner, help us analyze all the offenses and provide us a guideline on which can fall, especially the petitioner, what kinds of offenses can be committed in what way, and when can they be committed in relation to office. In this particular information, Solgen, unless you are able to really say that Secretary de Lima could have raised the 10 million except if she were the secretary, except unless she were the Secretary of Justice, the ordinary reading of the information and the resolution and the affidavits that use the resolution will really point out to the fact that she could not have at all even tried to conceive of this unless she were Secretary of Justice. And she could not have at all gotten her co-conspirator, Mr. Ragos, to join her unless he was the OIC of the Bureau of Corrections. And to me, it is very plain, therefore, that such kinds of offenses in relation to the drugs law, drug trading inside the NBP, this is committed in relation to the office. So that is a simple reading that I have. Maybe you have a more sophisticated way of presenting it to us and saying that no, it wasn't in relation to her office as to negate the language of the Sandigan Bayan law. That's the dilemma that the court now faces.
I promise you, Your Honor, we will put that in our memorandum.
Okay.
So that you'll be convinced that it is the RTC that has jurisdiction.
All right. Now you see, we have had already decisions where we gave relief to a party even when we corrected, for example, jurisprudence. In the case of Ombudsman versus Binay. In Ombudsman versus Binay, we did not find that the CA division that issued the TRO was in grave abuse of discretion. And yet, we corrected part of the jurisprudence so that the criminal law justice will be in place. In other words, we can actually grant partial relief to petitioners without necessarily having to say that Judge Guerrero was in grave abuse of discretion. Okay. But of course, when I look at the information and I look at the resolution, if if the judge had been looking at the statements in that information, resolution, and the affidavits, it would have really struck out the fact that all the acts against which Secretary de Lima is being pinned down are really in relation to her office. So she should be cognizant, in fact, of the possibility that the motion to quash was correct, which was already pending in her office. It is, you are right, Solicitor General, that actually there is nothing in the rules that say resolve the motion to quash before you issue the warrant of arrest. What if we do not say that, we do not say that she committed error in jurisdiction in issuing the warrant of arrest, she was correct, but because of our finding that she does not in fact have jurisdiction, we will then quash the warrant of arrest. That's also possible, Mr. Solicitor General. Right?
In the realm of possibility, Your Honor, possibility, nothing is too difficult, Your Honor. However, it is our submission that since the motion to quash is already in the sala of Judge Guerrero,
Okay.
let her finish her
Yes,
task,
we can
Your
also do that, but if it is denied, then Senator De Lima will have to go to the Court of Appeals, and then after it is denied, then Senator De Lima will go to us. I know that that is the ideal route.
That is
but
the
here we
hierarchy
are
of-
yes, that's the hierarchy, of course, and you're really correct and very respectful of the judicial hierarchy, and that's really recognized by us. But the problem is, because the campaign against illegal drugs will be taking on a high gear, as promised by government, we have and we are confronted with the opportunity to provide stability now to the system by ruling on the matter of jurisdiction. And we can say, as we have done in many cases, that for now the procedural errors are not as overpowering as we look at them for the moment, because we have a problem of introducing stability to the administration of justice. So will you take that into consideration? Help us, because we
Yes.
have to be, as the Supreme Court, we have to ensure that our rules are quite uniform, applicable to situations of similar import.
My only suggestion, Your Honor, and this is some sort of a caveat, if this honorable court will decide that way, Your Honor, isn't this some sort of a special treatment to a senator? What if the accused is an ordinary person?
Well,
So
an
that should be also
yeah, I
taken into
understand.
the
Yes, I
taken
understand.
into account, Your Honor.
Yes, I understand that the message must be clear. The court, if it grants partially or fully the prayers or the petition of Senator De Lima, must not give the impression that it is because
Yes.
she is a senator. I agree
Yes.
with you, Solgen.
Thank
But
you, Your Honor.
In fact, that is the reason why I also dissented in the case of Enrile, the grant of bail.
Together
to-
with Justice Leonen.
Yes, but
I salute you, Chief Justice.
But I really am worried about whether the DOJ and the Ombudsman will be properly guided in this instance. So I actually had been thinking aloud, I had been thinking whether it would have been better if we had asked the Ombudsman to join us for this hearing. But that's too late now. But we need to really find out what is the best way of handling investigations and prosecution, and what is the best way to really handle the drug-related offenses that may have been encouraged by persons who are in high positions of authority, because that's really a major concern by everyone, I think. So,
My concern there in
Yes.
asking that, in saying that, Your Honor, is I read the dissenting opinion of Justice Leonen, and I'm impressed. He said, if it is pro hac vice, then it amounts to selective justice. It is meant to apply in a blanket manner for all other detainees. Then it will weaken the administration of justice because the judicial standards are not clear. So that's it, Your Honor.
yeah. So thank you. Thank you for your views. Any other question? Ikaw ba? Gusto mo?
Very
Justice
brief,
Reyes,
queries.
Justice Hardilesa, and then Justice Martirez. In that order,
I
please.
just want to be enlightened on certain points of or matters. Good afternoon, Mr. Solicitor General.
Yes,
This
sir.
is in particular regarding the offense charge. The counsel for the petitioner argued that there is a fundamental disagreement between the DOJ and the OSG as to the nature of the charges against the petitioner. The counsel of the petitioner said that while the DOJ has charged the petitioner with the crime of illegal drug trading under Section 5 of the Dangerous Drugs Act of Republic Act, number 9165, the OSG now says that the charge against the petitioner is in conspiracy to engage in illegal drug trading under Section 26B of the same law. Can you comment on this, Mr. Counsel?
Thank you, Your Honor. As I said in my opening statement, there's really no real disagreement concerning the crime charge, because what we did, referring to my office, was look at the recital of facts. The title or the preamble of the information is not the controlling factor in ferreting out what is really the charge, the offense committed. And based on the recital of facts, the DOJ prosecutors and my solicitors, we had a meeting and we arrived at a common decision that the crime charged in the recital of the information was violation of Section 26B of RA 9165 in relation to Section 3JJ and Section 5 of the Dangerous Drugs Act, Your Honor.
There is no conflict
No conflict at all, Your Honor.
at all.
Because what is important is what is placed in the recital of facts, Your Honor.
But would you think that the apparent conflict, as pointed out by the petitioner, would weaken the prosecution of the case against former Secretary de Lima and now the Senator?
Well, I will not hazard a guess at this time, Your Honor. But under the rules, there's also a remedy for that amendment, Your Honor. As of now, we are confident that it will stand in court. But if there is really a necessity to amend it, then we will cross the bridge when we get there, Your Honor.
Would you agree with me, Mr. Solicitor General, that on the part of the petitioner, de Lima, it would be best if she just recognized the jurisdictions of the RTC, and this will not lead to the filing of this petition for certiorari, and the case will be disposed of immediately?
Well, I'm surprised why she filed this petition, Your Honor, when she was the one who filed the motion to quash. And she should have waited for the trial court to decide on her motion to quash, Your Honor.
The motion to quash. This is regarding the applications for the temporary restraining order filed by the petitioner. in our jurisdictions and our laws, there are two requisites for the issuance of the injunctive writ. The existence of a clear and unmistakable right to be protected, and coupled with the fact that the acts which are violative of the said right. Now, the petitioner asserted that Senator De Lima has a clear and unmistakable right warranting the grant of injunctive writ. Is the averment of the petitioner's counsel correct that since the lack of jurisdictions of the RTC is palpable, the requirement of clear and unmistakable right is already satisfied in favor of the petitioner?
With due respect, Your Honor, I do not agree with such argument of the petitioner. I don't see any clear right for her to enjoin the warrant of arrest, and in fact, she's now in detention. It's already a fait accompli, Your Honor. What is there to stop? She's already detained.
So this is the burden lies with the petitioner.
Yes, Your Honor.
All right. Thank you very much.
Thank you also, Your Honor.
Justice Ardileza.
Mr. Soljan, good afternoon.
Good afternoon, sir.
May I go back to the hypothetical posed to you by Justice Leonen? I believe the hypothetical was assume a drug prosecution. The information says possession or sale of drugs, and the information is filed with the MTC. If you were the MTC judge, what will you do, Mr. Soljan?
In that hypothetical situation, I'm the MTC judge, and the case before my Sala is murder.
It's drugs. Sale, possession of drugs in Makati, and you are an MTC Makati.
MTC. Well, I will tell the prosecutor, Your Honor, you file it in the RTC. Because under Section 90 of RA 9165, it is the RTC that has exclusive and original jurisdiction over drug offenses punished under RA 9165, Your Honor.
So you will do that, Mr. Soljan, because jurisdiction is important.
Yes,
subject matter jurisdiction is important in a criminal prosecution.
And besides, Your Honor, if I were that MTC judge, I would know the law, Your Honor.
Yes. Now, is there a constitutional right for the accused to be tried before a competent court?
Yes, Your Honor. That's why we have rules to that effect in the rules of court, that the accused can file a motion to quash if she believes that the court has no jurisdiction. And that's what happened in this case, Your Honor. De Lima filed a motion to quash before Judge Guerrero. And Judge Guerrero is a competent judge to rule on that motion. But instead of waiting for Judge Guerrero to rule on the motion, De Lima went up directly to the Supreme Court. That is a violation of the hierarchy of courts, as well as the forum shopping, Your Honor. We cannot countenance that, Your Honor.
Now, I'll go back to the basic premise that an accused has a constitutional right to be tried in the court of competent jurisdiction. And you're saying that is important because if the court that tries the accused is not a court of competent jurisdiction, what happens?
Well, he cannot decide and try the case because that is what jurisdiction is. The power of the court to hear, try, and decide a case.
And it will be such a waste of time to try a case only at the end for the judge to say that he or she has no jurisdiction, right?
Well, as I said, Your Honor, there are procedures in the rules of court. The judge, knowing her position as RTC, she knows what types of cases will, what types of cases she can try, decide, and case based on the law, Your Honor, and the facts.
To cut to the chase, Mr. Solgen, here, as you said, the petitioner filed a motion to quash.
Yes, Your Honor.
Now, Judge Guerrero could have, did she have an obligation, constitutional obligation, to rule on the motion to quash together with the motion to quash on the lack of subject matter jurisdiction together with probable cause?
Well, Your Honor, I cited the case of Marcos versus Cabrera Fallar, Your Honor, that the first and foremost duty of a judge is to determine the existence or non-existence of probable cause. And that is a ruling of this honorable court.
But you just said a while ago, Mr. Solgen, if you were the MTC judge, a drug case is filed before your sala, you are an MTC judge, you don't have jurisdiction, even without a motion to quash, you will dismiss the case and tell the prosecutor, file it in the proper court.
Yes.
Now, did Judge Guerrero have the constitutional duty when the motion to quash was filed to rule? The other way to put it is, what was so burdensome on the part of Justice Guerrero that she could have just ruled on the subject matter jurisdiction because it was already raised?
Actually, it was already set for hearing, Your Honor. She could have ruled had she not, had the LIMA not go directly to the Supreme Court.
But, Mr. Solgen, I think she ruled that it would be heard in 10 days, if I am not mistaken. That was the order of the judge. But the substance of what I'm trying to say is, remember, you are talking here of liberty. And I go back to my conversation with the former Solgen. The basic premise comes from the due process clause, Mr. Solgen. No person shall be deprived of life, liberty, or property without due process of law. In a criminal prosecution, liberty is implicated. What I'm driving at is, you know, you can hear the motion to quash within 10 days. I know under Section 117, it is heard at any time. But as a constitutional rule, where it is raised, and this is the submission of the petitioner, where it is raised because it implicates her liberty, shouldn't that be the duty of the courts to decide the motion to quash based on subject matter jurisdiction together with the decision on probable cause?
No, Your Honor, because we are following the decision. As for me, I speak for myself. There is already a decided case and back by the Supreme Court.
And you're referring to the Fallier case.
Yes, Your Honor.
And we're saying, and as Justice Leonen said, that is an administrative case. The other way to put it, counsel, is this. There is a duty for the judge to decide on probable cause because that is what the Constitution says. Why are you saying it excludes a similar constitutional duty to decide on subject matter jurisdiction together with probable cause? Because if the judge postpones resolution of the question of subject matter jurisdiction, there is a continuing impingement of the liberty of the accused. I think that's what the Chief Justice was trying to ask you. The other way to put it, what is the burden on the government? What is the burden on Judge Guerrero to rule at the same time? Because she could just have added a paragraph or two into her order on probable cause on subject matter jurisdiction. What is so burdensome of that, with that, as against the liberty? Every minute that an accused stays under detention is a minute under detention.
May I answer in this manner, Your Honor? If I were Judge Guerrero, and by the way, Judge Guerrero is a veteran trial court judge, Your Honor. If I were her, and this information and the evidence was before my sala, I would know from the information what is the offense charge. Is it a violation of, and it's very clear, it's a violation of RA 9165. Okay. As a judge, I would know, and I ought to know, what RA 9165 Section 90 says. And it says here that the RTC has exclusive original jurisdiction to hear and try drug offenses punishable under RA 9165. And then I would assess the evidence attached to the information, and if it is my judgment that there is substantial basis to issue a warrant of arrest, I will do it, Your Honor. Why? Because there's also a policy of the state that the criminals should not be allowed to roam freely, Your Honor. They must be brought within the custody of the law. So on one side there's liberty, on the other side there is also this state policy. So we will discuss that, Your Honor, if you will allow us, in our memorandum.
Now, Mr. Solgen, on the matter of jurisdiction, you have heard many of the justices on that issue. I have not myself gone into that line of questioning. What is your impression? Did the justices who asked you questions, are they unanimous in that it is the Sandigan Bayan that has jurisdiction over the offense charge?
I'd like to believe, Your Honor, that I convinced most of you that the jurisdiction really is RTC, not Sandigan Bayan.
Well, that is a hope. Well, I understand from where you're coming from. You are saying it's RTC. My question is, from what you have heard from them, and before you arrive at the result that you have convinced them, from what you have heard so far, are there some who think it's RTC, and are there some who think it's Sandigan Bayan?
Your Honor, I cannot read the minds of the honorable justices.
No, you cannot read the minds, but I am just asking, in effect, the question is there an issue before the members of the court on which has jurisdiction? Is it RTC or is it Sandigan Bayan? Or there is no issue? Or is the issue a sham issue, a patently sham issue?
Well, I'd rather not comment on it, Your Honor.
What I'm driving at, Mr. Solgen, is that from what I hear, there seems to me to be an issue. Now, whether it is a genuine issue, a patently genuine issue, or patently non-issue is a matter of interpretation. From what I hear, I think there is an issue. And in the same manner, petitioner has raised an issue with her motion to quash. And so I go back to my question. If subject matter jurisdiction, the right, there is a constitutional right to be tried in the court of competent jurisdiction, shouldn't it follow that there is a constitutional right that the question of jurisdiction of which court should have the same precedence, importance, and should be decided simultaneously, not later than the resolution on the subject of probable cause?
Well, in my humble opinion, Your Honor, I don't see any constitutional issue that has to be resolved.
The constitutional issue I'm suggesting to you, Mr. Soljan, is, again, the due process clause. An accused has the right to liberty. The court can discuss at end, is it RTC, is it Sandigan Bayan? In the meantime, the liberty of the accused, while we debate, and it will take us several months to debate, which is it, and not to mention your valiant efforts to convince them to your side, in the meantime, the person is deprived of liberty. And I call your attention, Mr. Soljan, that's because I in a constitutional case, I think whenever an issue of the Constitution is raised, it is an important issue. It is an important question because all constitutional questions are important. And when you talk of due process of law, I say it says person, no person. So every person is special. No person should be deprived of life, liberty, or property without due process of law. So what makes a constitutional litigation issue important or special is that it implicates the Constitution. It has nothing to do whether the petitioner is a pauper or a senator or a congressman. So I go back, and I think when you develop your memorandum, you go back to the question. I submit to you that there is a constitutional right to be tried by the competent court as a matter of substantive law, as a matter of procedural law, and that the judge need not wait to rule on the motion to quash, but should decide the motion to quash based on subject matter jurisdiction simultaneously with not later than ruling on probable cause.
Rest assured, Mr. Justice, we will include all our arguments in the memorandum to convince this honorable court that we are right.
Thank you, Mr. Soljan.
Thank you also, Mr. Justice.
Justice Martirez.
Thank you, Madam Chief Justice. Could you ask your staff to provide you a copy of Republic Act 3019, or do you have a copy? I'd like to ask you, would you know the reason why PD 1606 was amended by Republic Act then 660?
I think one of the legislative intent there, Your Honor, is to declog the dockets of the Sandigan Bayan, Your Honor.
On February 26, 2014, when Senate bill was introduced by Senator Franklin Drelon, Senate Bill 2138, he specifically mentioned 3 reasons for the introduction of the amendatory law. He said 1 is the concept of justice designate, the reduction of the voting requirement from 3 to 2, and the streamlining of the jurisdiction of the Sandigan Bayan by transferring cases to the regional trial court. Now, you go over Section 4 of 10660, specifically after letter C, provided that the regional trial court shall have exclusive original jurisdiction where the information, letter A, does not allege any damage to the government and so forth. It mentions the word bribery. Is the word bribery under this Republic Act 10660 the same as the bribery contemplated under the revised penal code?
I would like to think so, yes, Your Honor.
Could you go over the provisions of Republic Act 3019 and look into the provisions of sections 3B and C? Read the provisions of 3B and C.
3B and C. Okay. Section 3B.
3B, directly or indirectly?
Directly or indirectly requesting or receiving any gift, present, share, percentage benefit for himself.
Is this not the concept of bribery under Republic Act 3019?
This is what I read, Your Honor.
What about letter C?
3019.
What about letter C?
Directly
3C.
or indirectly requesting or receiving any gift, present, or other pecuniary or material benefit for himself or for another from any person for whom the public officer or in any manner or capacity has secured or obtained or will secure and obtain any government permit or license in consideration for the help given or to be given without prejudice to Section 13 of this Act.
So the bribery under Republic Act 10660 is not the bribery contemplated under the revised penal code, but the bribery contemplated under 3019, particularly sections 3, B, and C. Is that correct?
Well, this law was approved in August 17, 1960. We have the amendatory law, which is RA number 10660, Your Honor.
Yes, I'm talking about Republic Act 3019.
Okay.
It speaks of bribery under section 3B and C. So my question is, the bribery mentioned in section 4 of Republic Act 10660, is this not the bribery contemplated by the Anti-Graft and Corrupt Practices Act?
210. Well, there are similarities in the wording, although it is
What is the similarity in the wording between the bribery under the revised penal code and the bribery contemplated under the Anti-Graft and Corrupt Practices Act?
Well, in this
The receiving of gift?
RA 3019, Your Honor, they lump together directly or indirectly, direct and indirect bribery.
Could you go over the provisions of section 3 and tell us what are offenses that are committed in relation to office and offenses that may not be committed in relation to office? You have A to K of Republic Act 3019. What are the offenses that are committed in relation to office and offenses that may not be committed in relation to office, or that may be committed but not in relation to office?
May I be allowed, Your Honor,
Yes.
to discuss this matter in our memorandum, considering the length of this provision?
Could you read section 3A?
3A.
Apple, persuading, inducing, or influencing another public officer. Is this committed in relation to office?
It would depend on the factual, on the facts of the case, Your Honor. This is just a general statement of law, Your Honor.
The main purpose, one of the main purposes of amending the Sandigan Bayan law was to declug the dockets of the court,
Yes, Your
to
Honor.
transfer cases to the regional trial courts.
Yes, Your Honor.
Is violation of the dangerous drugs law a quantifiable offense? Is violation of the dangerous drugs law a quantifiable offense that would make it fall under the jurisdiction of the Sandigan Bayan?
In my humble submission, no, Your Honor.
I would advise you to read the deliberations of the Senate with respect to this matter, because both Senators Drilon and Pimentel were talking about quantifiable and unquantifiable offenses. If you read 3019, there are offenses that are unquantifiable. In fact, only Section 3E would definitely fall under the term quantifiable. Section 3A cannot be quantified. Section 3D cannot be quantified. So if this is unquantifiable, it goes to the RTC.
Yes, Your Honor.
And if you are saying that the violation of the dangerous drugs law is unquantifiable, to follow your logic, it falls within the jurisdiction of the RTC.
I agree, Your Honor. Yes.
And that's okay. That's all. Thank you very much.
Thank you, Your Honor.
Justice Leonen. I'm sorry. Justice Leonen now.
Good evening, Counsel.
Yes, Your Honor.
Marcos versus Cabrera-Fallier is a precedent that you have cited. And if you recall, it is a per curiam decision of this court. Do you recall that? Per curiam meaning to say that it's written by one of us, but it's a bit anonymous, correct? Because
Your
it actually resulted in the dismissal of a judge. This is Judge Cabrera-Fallier. Of course, I cannot tell you who actually wrote it, but I can say that he is one of the most erudite justices of this Supreme Court. That's all I can say.
Will that be you, Your Honor?
No, not me, because I'm not that erudite. But in that particular case, the actual offense of the judge was to recall a warrant that she issued immediately after issuing it. And therefore, on that occasion, the Supreme Court en banc said that she should not have done that because her duty is to issue the warrant of arrest as soon as the case is filed. The issue was not whether she should issue the warrant if there is a pending motion to quash. In other words, there was no question about her jurisdiction. I think this was related to a fraternity case that resulted in a death. And certainly, she had jurisdiction over the subject matter. Now, are you still of the opinion that it is squarely a precedent for this particular case?
Well, at least the ruling that the first and foremost thing that the judge should do is to determine the existence or non-existence of probable cause. We accept that thoroughly.
In general, but it is not the situation in that case that there was a question about the jurisdiction over the subject matter of the judge. Am I correct? It was only, there was no question, it was she had jurisdiction over the subject matter. The issue was why she recalled the warrant immediately upon issuing it. And this court found that there was something wrong, fundamentally wrong with it, and that caused her dismissal. Okay. In any case, I suppose that you will discuss why you were citing it as a precedent for this case when it is not on all fours. But I will invite you to cover that in your memorandum.
Yes, Your Honor.
Now, I want to pursue this concept of aggravating circumstances. Taking advantage of one's office was only an aggravating circumstance. That's your theory, correct?
Yes, Your Honor.
Let me just start so that I lay the foundation. This concept of aggravating circumstance, may I know what law introduced the concept of aggravating circumstance, just for our public, so they can follow our discussion? What law introduced the concept of aggravating circumstances in general?
The revised penal code, Your
The
Honor.
revised penal code. Can you please read section 98 of Republic Act 9165?
Section
98.
98.
9165. This is the drugs law, and you have there section 98. Please read into the record section 98. So, we start with the premise that aggravating circumstances, the concept is revised penal code, correct?
Yes,
Now, please read section 98.
Section 98, limited applicability of the revised penal code. Notwithstanding any law, rule, or regulation to the contrary, the provisions of the revised penal code, Act Number 3814, as amended, shall not apply to the provisions of this act except in the case of minor offenders. Where the offender is a minor, the penalty for acts punishable by life imprisonment to death provided herein shall be reclusion perpetua to death.
In other words, Mr. Solicitor General, the revised penal code does not apply unless the accused is a minor. Is Secretary de Lima a minor?
Well, I think she's not
She's
a
not.
minor, Your Honor.
You're not sure, but maybe that can be the subject of a stipulation. But in any case, because your theory is that it is only aggravating, but it is clear in section 98 that the revised penal code does not apply, then perhaps you can explain that further in your memoranda.
Yes, Your Honor.
Not at present. But let me pursue that. Section 98. Conspiracy is, if it is a crime, there are two things that you need to prove. Conspiracy means unity in intent and unity in action, correct?
Yes, Your Honor.
Yes. If the revised penal code does not apply in 9165, therefore it is mala prohibita, not mala in se. Therefore, it cannot be that it is conspiracy the way that the respondents are imagining conspiracy, correct?
Well, the law itself, RA 9165, makes it a crime to attempt, if there's an attempt or conspiracy to commit illegal drug trading, that is a crime in itself, Your Honor.
So again, in the light of section 98, can you please cover that? What kind of conspiracy is covered by section 26B, if at all it is considered as a separate offense? Because that is now the unified theory, according to you, of the DOJ and the OSG.
Yes, Your Honor.
So I'll go quickly to my next 2 points. Jurisdiction. First, the judge determines jurisdiction, whether she has jurisdiction over the subject matter, correct? And as a matter of fact, if she does not have jurisdiction over the subject matter, can't this not be raised for the first time on appeal? It can. If she does not have jurisdiction over the subject matter, she does not have to wait for a motion to dismiss or a motion to quash. As a matter of fact, judges are given the jurisdiction or the competence to determine their competence.
Correct.
And therefore, she can dismiss it motu proprio.
That's the competence rule, Your Honor.
Very good. Now, if she did have that, but instead of doing that, she issued the warrant of arrest, then therefore, could it not be that she has already denied the motion, calling her attention to the fact that she did not have competence over the case?
Well, are we talking of Judge Guerrero here, Your Honor?
Judge Guerrero. Judge Guerrero did not act by saying that she did not have jurisdiction over the subject matter. She already found out that she had jurisdiction over the subject matter. She moved on to a next part of jurisdiction, which is to acquire jurisdiction over the person. Could we not say, therefore, that the judge effectively denied the motion to quash?
Not necessarily, Your Honor.
And as a matter of fact, perhaps you can cover that, but it is also strange that the petitioner's petition seems to assume that she has not yet acted on the motion to quash. But you have a competence to determine your competence first. Determining that, you can have the power to acquire the person of the accused by arrest. Then after that, you go into the merits of the case. But nonetheless, I hope both parties will cover it because the petition seems to imply that they want this court to order the judge to act on the motion to quash. That's the relief that I read from the petition. Am I
And
not correct?
at the same time, to stop the judge from doing anything, Your Honor,
Okay.
which is a paradox.
Yes. Now, the Sandigan Bayan's jurisdiction. While it may be true that it wants to do away with some cases within its jurisdiction under 10660, and that is covered precisely by the amendments which were discussed, I think, by Justice Carpio last meeting and this meeting, this session. Still, to remove some of the offenses, could it not have been the intent of the law to focus on the high-profile leveraged cases, the cases that really matter to the public, and give it to a Sandigan Bayan with 3 justices with appellate level rank? In other words, the purpose of 10660 is to make the jurisdiction of the Sandigan Bayan not less but efficient. And to help them do that, they have to remove some of their jurisdiction over some other offenses, those below 1 million in terms of bribery and so on and so forth, but focus on the high-profile case. Could that be possible, Mr. Solgen?
We will discuss that in our memorandum, Your
Yes,
Honor.
please do. And finally, you are of course aware that you were mentioned in the affidavit of J.B. Sebastian.
I was mentioned, Your Honor.
I thought you went through it. You
I
were
didn't-
mentioned
as
as having gone to the Bilibid, and then after that, he explained that after you, the follow-ups were done by a certain Miss Sandra Cam.
Who, Your Honor?
Sandra Cam.
I'm not aware of that, Your Honor.
It's in the affidavit in your submission. Just that you are aware.
Unfortunately, as I confessed, I did not read all the affidavits, Your Honor.
Thank you, Mr. Solgen.
Thank you, Your Honor.
I just want to volunteer something for the enlightenment of everybody, if I am correct. Now, under Section 98, the law provides that if the offender is a minor, the penalty is life imprisonment to death, then the penalty shall be reclusion perpetua to death. You look at it. If the offender is a minor, and the penalty is life imprisonment to death, then the penalty is converted to a penalty of reclusion perpetua to death. Now, the implication of that is that when a law adopts the nomenclature of penalties under the revised penal code, then the revised penal code will apply. Do you follow?
Yes, Your Honor.
Okay. Now, dangerous drugs law was enacted in 2002. At that time, there was still a law of death penalty law, because the death penalty law, abolishing it, was in 2006. Okay. If the offender is a minor and is found in possession of more than 10 grams of shabu in the company of 2 or 3 persons under Section 13, then the maximum penalty shall be imposed. So there is a danger that if a minor between the ages of 15 and 18 acting with discernment in the company of 2 or more persons in possession of more than 10 grams, the penalty of death may be imposed, because the penalty when the quantity is more than 10 grams is life imprisonment to death. So if he is in company of 2 or more persons or in a social gathering, the maximum penalty shall be imposed. So the penalty of death shall be imposed to that minor. But because of Section 98, there is no possibility that the minor will be imposed the penalty of death. Why? Because if the penalty is reclusion perpetua to death, and that is what is provided in Section 98, and therefore it is now a penalty under the revised penal code, then the penalty shall be lowered by 1 degree. Because under the revised penal code, if the penalty is reclusion perpetua to death, and it's a privileged mitigating circumstance, the penalty is reduced to reclusion temporal. Therefore, there is no possibility that the minor offender will be imposed the penalty of death. That is the purpose of Section 98. Because that is the doctrine in People versus Martin Simon, that if the crime is punishable by special law, but adopts the nomenclature of penalties under the revised penal code, then the revised penal code shall apply as a general rule.
Thank you for that
All right.
piece of wisdom, Your Honor. Thank you.
Justice Velasco, for the final question.
I go back to the first issue that petitioner raised, that respondent judge should have first resolved the motion to quash before she issued the question, order, and warrant of arrest. I want you to discuss the ruling in Miranda versus Tulyao in your memorandum. I want you to discuss what particular situation retired Court of Appeals Justice Oscar Herrera stated in his remedial law book, no? And that is cited in Miranda versus Tulyao. And it is with respect to his statement that the outright dismissal of the case, even before the court acquires jurisdiction over the person of the accused, is authorized under Section 6, Letter A, Rule 112 of the Rules of Court. I want you to explain that because I noticed that Justice Herrera never mentioned a pending motion to quash when he made this annotation or comment on Rule 112, particularly Section 6, Letter A. Likewise, I want you to discuss in your memorandum, and even the counsel for petitioner should look into this. There is a statement on page 391 of volume 486 of ISCRA, no? March 31, 2006, no? And there is mention there about Aliado versus Jokno, Roberts versus Court of Appeals, and Lacson versus Executive Secretary. And there's a statement there that and I quote, "Note that none of these cases involve the application for bail, nor a motion to quash information due to lack of jurisdiction over a person, nor a motion to quash a warrant of arrest." So for both parties, I want you to discuss this in your memorandum because we are quite serious about following the rule on hierarchy of courts. And there are thousands of cases still pending before the court, and that there are so many case inflows that we receive almost every day. And I stated during the last oral arguments that for the year 2016 alone, there are 204,000 criminal cases filed before the regional trial courts only. So you can just imagine if we allow and entertain this petition now, and they will use this case as a precedent in the cases to be filed this year or in the near future, then the Supreme Court will be deluged with a lot of petitions under Rule 65 to question the order of the trial court finding probable cause to issue warrant of arrest. Okay? Now, I just want to clarify certain matters regarding probable cause, no? So, what do you mean by probable cause to issue, to file a case before the court, to file a charge or an information before the court? What do you mean by probable cause?
Well, there's a definition of probable cause, Your Honor.
And that's the job of the prosecutor, right? Criminal
Yes, Your Honor.
complaint is filed and
Probable
is
cause.
required to determine whether there's probable cause. And what does that mean?
Probable cause for the issuance of a warrant of arrest is the existence of such facts and circumstances that would lead a reasonably discreet and prudent person to believe that an offense was committed by the person sought to be arrested. This must be distinguished from the prosecutor's finding of probable cause, which is for the filing of the proper criminal information. Probable cause for warrant of arrest is determined to address the necessity of placing the accused under custody in order not to frustrate the ends of justice.
Okay.
This is Mendoza versus People, Your
Probable cause is to
Honor.
determine whether an offense has been committed and that the accused is probably guilty thereof,
Guilty
or
thereof.
has committed it. Correct?
Yes, Your Honor.
That's the job of the prosecutor.
Yes,
now, what
Your
is the job of the judge? And in determining probable cause to issue a warrant of arrest, specifically, what is the job or the duty of a trial court judge with regard to whether he or she will issue a warrant of arrest? What does probable cause mean?
The judicial determination of probable cause, on the other hand, Your Honor, is one made by the judge to ascertain whether a warrant of arrest should be issued against the accused. The judge must satisfy himself that based on the evidence submitted, there is necessity for placing the accused under custody in order not to frustrate the ends of justice. If the judge finds no probable cause, the judge cannot be forced to issue the warrant.
Okay, I cite Baltasar versus People, and we said probable cause is such set of facts and circumstances as would lead a reasonably discreet and prudent man to believe that the offense charged in the information has been committed by the person sought to be arrested. So the only duty of a trial court judge in determining probable cause is whether or not the facts laid before him would constitute a sufficient basis to help to conclude that the person to be arrested can be arrested by the warrant of arrest. Is that correct?
Yes, Your Honor, it's
So
correct.
that is the only duty of the judge. And what kind of procedure is there in determining probable cause? Can the accused participate in the determination of probable cause to issue warrant?
Well, what is necessary is only a substantial basis, Your Honor.
Yes, but the accused does not usually participate because
Yes.
under the rules it's
Yes, Your Honor.
solely the prerogative of the judge.
Correct, Your
But
Honor.
there must be some basis from the facts and circumstances of the case
Yes, Your Honor.
before he or she can issue the warrant of arrest, correct?
Correct, Your Honor.
Okay. And what degree or nature of discretion is given to the judge when she is determining probable cause to issue warrant of arrest?
Well, it says here in the definition, a reasonably discreet and prudent person. So prudence and discretion, Your Honor.
Okay. In this case, did Judge Guerrero have sufficient basis to issue the order and the warrant of arrest?
Yes, Your Honor.
And what are these facts borne out by the evidence presented during the preliminary investigation?
Well, the judge probably looked at the information and the resolution of the prosecutors as well as the evidence attached to said pleadings, Your Honor.
If an accused believes that the court has no jurisdiction over the person or over the subject matter of the offense, what kind of motion or pleading does he file?
Actually, Your Honor, she can decide to dismiss the case outright.
No. I'm talking about the accused. If the accused because in the determination of probable cause to issue warrant of arrest, the accused does not participate, correct?
Yes, Your Honor, yes.
As a matter of fact, a motion to determine probable cause to issue warrant of arrest is actually a prohibited pleading, correct?
Yes, Your Honor.
And the court will decide, it's mandatory upon the court to decide the issue whether there is probable cause to issue the warrant of arrest within 10 days. It's mandatory, correct?
Correct, Your Honor.
Okay. So, under the rules, it should be a motion to quash that should be filed by the accused, correct?
Yes, Your Honor, and it's provided in Rule 117, Your Honor.
Correct. Okay. If we will now rule on the ground of lack of jurisdiction over the subject matter of the offense. What particular rules will be practically disregarded? First, you tell me if the accused or the respondent in a criminal complaint, what motion can he file if there's an adverse resolution from the prosecutor?
From the prosecutor,
Yes,
Your
resolution
Honor.
from the prosecutor for the filing of the information. What can he file from the
Well,
adverse
she can ask for
resolution?
a reinvestigation, Your Honor.
Reinvestigation.
Yes, Your Honor.
Or
motion for reconsideration.
Or motion for reconsideration. If it's denied, then he goes to
Well, if there is grave abuse of discretion,
he goes to the Department of Justice or the
Yes, Your
Secretary of
Honor.
Justice
Yes.
first, correct?
Correct,
Then
Your
he
Honor.
goes to the Court of Appeals.
correct, Your Honor.
Then he goes to the Supreme Court.
Yes,
Okay.
Your Honor. That's the hierarchy of courts, Your Honor.
All right. Now, there is a pending motion to quash before the RTC of Muntinlupa, okay? And the judge is supposed to decide the motion or resolve the motion, correct?
Yes, Your Honor.
So these two tracks to question the resolution finding him as an accused before the court and subject of an information, these two tracks, the administrative track going to the Secretary of Justice and then later to the Court of Appeals and the Supreme Court, and with respect to the procedure allowed to the accused pending in the case pending before the RTC, all these things will be disregarded by this court if we decide now that the RTC has no jurisdiction over the offense captured in the information, correct?
That's what we...
Supreme Court will now be disregarding all the rules that are laid down for the orderly procedure, and we will disregard also possibly the rights of the people of the Philippines, and also if there is an offended party, this will all be disregarded because a petitioner went to us and we will be ruling directly in disregard of all these rules on a petition filed by the accused, correct?
I couldn't agree better than that, Your Honor. You
There
said
are
it
two
well.
senators which are now detained in detention centers. They've been detained for 4 years. They question probable cause in the issuance of the warrant of the filing of the information before the court, and we denied. I think a case already raising lack of probable cause to file the information. What is the difference between the two senators in detention now, and they've been detained for 4 years, and Petitioner LIMA?
None, Your Honor.
None. Okay, can you discuss all these things, the prejudicial effects of direct ruling from this court in your memorandum?
Yes, Your Honor, we will do that. Thank you.
Thank you very much, Solicitor General. You may now please take your seat.
Thank
and
you,
I
ma'am. Thank you,
request
Chief.
all the others, please, other councils to please rise as final instructions will be given you. Both parties are hereby required to submit their memoranda, respectively serving them personally on the opposite counsel. And in such memoranda, address all the questions or observations that were made by the justices during the interpellation, as well as the main issues that are contained in the advisory to the oral arguments. After the simultaneous submission of your memoranda within 20 days hereof, the case will be deemed submitted for decision. This session is hereby adjourned.
Please remain standing while the Chief Justice and the Associate Justices
20 days.
lead the session.